Well, it only seems to be us so far.
Yeah, yeah.
Yes.
Which is not good. Yeah.
Right, good morning, everyone. The court has reconvened for the Bermuda Health Council appeal. The appearances are as before. So, Mr. My Lord President.
Yes, Mr. Robinson, here we are, a little earlier than usual, but thank you very much.
Thank you, my Lord, thank you for adjourning at 3:15 rather than 3:30 on Friday to allow me a fresh start this morning. So, my Lord, my submissions will be divided into roughly into 5 different categories, which really mirror my learned friend Mr. Adamson's submissions. And I'll deal firstly with the issue of fettering of discretion and nationality. Secondly, the issue of irrelevant considerations. Thirdly, the issue of bias, broken into 2 parts, Dr. Braithwaite and Dr. Richmond. Fourth, the reasons challenge, and fifthly, the remedy.
Yes.
And so, Lord, if I could start with the issue of fettering of discretion and rationality. This is dealt with by the judge in 2 different sections in his ruling. But in my submission, and I think Mr. Robinson may agree with this, the issue of rationality and discretion, the judge's reasoning overlaps in respect of both of those issues. And the very central issue with regard to both of those issues is the question of the judge's conclusion that the council or the Second Appeal Tribunal ought to have considered the application of Dr. Soares in the Hamilton Medical Centre as a full year application. So in order to deal with that issue and that very central issue, I will need to go back to some of the documents, and I'll take some of the documents as quickly as I possibly can. But in my submission,
Don't feel the need to rush.
No, my Lord, I'll take it as slowly as I can.
No, I don't do it very slowly. It's just that I'm actually interested in A, hearing what you say, B, understanding it, and C, if possible, making a brief note.
Yes, of course, my Lord. And I'm afraid, coming from the part of the world that I come from, I do have the tendency to speak quite quickly.
So I have a lot of experience at the part of the world.
I'm aware of that. So I'll try my best to take it as slowly and as carefully as I can. In our submission, my Lords and my Lady, the issue of chronology of Dr. Soares' application is absolutely central to the judge's reasoning in respect of why he held that it was wrong of the council not to treat it as a full year application. And Dr. Soares and the Hamilton Medical Centre started the construction of the new centre, if I can put it that way, in 2017. And so my learned friend, Mr. Adamson, on Friday made a point about the centre not opening until January 2021. And of course, that is correct. And of course, the context of the application by Dr. Soares for approval was made in the context of building a new medical centre. And I think it's fair to say that his expectation was that it would be open much more quickly than it ultimately was open in January 2021. But if I could take you back to the 2019 and the application which Dr. Soares did make. Now, we know that he made his application on the 27th, his final application, because there was a number of stages of that. He made his first application in March of 2019, and then he made his final submission on the 27th of June 2019.
And we don't have the March application and presumably don't need it.
Yes, that's quite right, my Lord. There was a number of iterations of his application. He made his first application on the same day that the moratorium was announced.
Right.
And he made, which was the 6th of March, 2019. And
Well,
then
we've got that application.
I'm sorry, my Lord?
We've got that application.
My Lord, the only application that the court has is the application which he made on the 27th of June, 2019. And that is in the, if you've got the C bundle to hand.
Oh, I see, because we've got the amended version.
Yes, exactly. So if you've got the C bundle to hand at page C49,
yes,
you'll see at the top left hand, you'll see the date 27th of June 2019.
Yes.
So the application which Dr. Soares, which ultimately was made and considered by the Health Council and the appeals tribunals, was the application which was dated the 27th of June 2019.
Yes, I see.
But this was effectively the third iteration of that application, which he had updated. I think, my lord, if you just keep your hand in C49 and just turn over to C87.
Yes.
And you'll see that this is a letter dated the 28th of June, which is the following day, which reads, Dear Dr. Brathwaite, thank you for your recent suggestions on making our SHB application more complete. Please find enclosed an updated application which should replace that submitted to you on the 28th of May 2019, save for the legal and other correspondence. For the sake of simplicity, I'm submitting complete documentation in its entirety once again. And then the final paragraph is irrelevant for present purposes.
So do you, there was an application in March 19, 28th of May 1919 and 27th of June?
Yes, exactly right. And I think the reason why there's a letter dated the 27th of June at C49 and then this letter on the 28th of June at C87 is because I think one was emailed and then one was hard copy. And so the 28th of June letter, which is at C87, is effectively the hard copy letter in which Dr. Soares is dropping in the physical application into the health.
I follow.
But in the event, the chronology is that the first application is made on the 6th of March. And there's an updated application in May. And then finally, the substantive application that the case is concerning when everyone is discussing is that dated the 27th of June 2019 at C49. You may not need to turn this up just to mention this point, but that chronology is in fact confirmed by Dr. Braithwaite's third affidavit at paragraph 10, which is page B436. And I can just read you out the sentence, and I won't ask you to turn up that separate file, but what he says in paragraph 10 is, we announced it, the moratorium, by email at 4:17 p.m. to all providers and received the applicant's partial application that evening. So, the chronology is the council announces the moratorium, and then the same day, but later that day, Dr. Soares files his application. Dr. Braithwaite refers to there's a partial application. As I've explained, it went through two previous iterations before we get to the 27th of June, which is the substantive application that was considered by the council.
Yeah.
So if I could then ask you to look at page C47, which is just the page before the substantive filing application. What happened was that Dr. Soares filed his application on the 6th of March in the evening, and then this issue was raised with regard to the moratorium, and Dr. Soares, in fact, while represented by Kennedy's, filed an appeal in respect of having his application considered at all. And the letter of the 4th of March 2019 is a letter from the Health Council to Mr. Alex Potts, QC at Kennedy's. And in my submission, this is an important letter in terms of getting the chronology right. And if I could ask you to, well, perhaps I think I'll take it up from the second paragraph. Your clients have appealed against our decision on the 6th of March 2019 to impose a moratorium on applications for the addition of benefits to SHB cover and on applications for approving new health facilities to provide existing benefits covered by SHB. Such SHB applications are considered by the Council in accordance with our published standard health benefit policy guide. Of course, that's the guide which we've been looking at in the hearing. The policy provides that applications should be received by July 1 to be considered for approval for the following 1 April, although provision is made for approvals mid-year. That's what we've been referring to as full year and mid-year applications. He then continues, the Minister of Health is currently undertaking a wide-ranging review of SHB coverage as part of the ongoing health financing reform initiatives and in light of policy objectives for universal coverage. It is anticipated that a fully redesigned SHB package of services will be announced later this year to commence on the 1st of April 2020. So pausing there, it's clear from this letter that Dr. Brathwaite is saying to Dr. Soares, the reform is underway and we anticipate having a revised SHB system by the 1st of April 2020. And as we know, that didn't happen for reasons which I need not go into. The letter then continues, any current...
Mr. Robinson, can I interrupt you, please?
Yes,
I'm trying to find a chronology, and the nearest I've got to it is on page B445, which is the applicant's chronology filed with these written submissions. I can't actually find it in the record, but where do I find it?
I don't believe it is I don't believe there is a chronology in the record.
Well, do you think you could let me have one, please? I mean,
Yes.
if there's one already, I've found one on your applicant's written submissions for hearing dated 23rd of February 2021 on B445. There's a reference to it there.
Yes,
I don't know whether it was agreed or not, but it would be very helpful to me to have that document.
yes, of course, we can certainly look at that. I don't believe there is one in the record, but I'm sorry if that would have been more helpful at the commencement, but we
Well,
can
it's
certainly...
just then I don't have to need, it's all, the work's been done sort of thing. So if I could have that, or if the court could have that, I'd be very grateful.
Yes, of course, we can deal with that.
Thank you.
If I could just then go back to the letter which I was opening at C47, which is dated the 4th of April 2019.
Sorry, C47.
C47, yes, sorry.
Yeah, thank you.
And I think I come sort of halfway down the page, the paragraph which starts, any current. Dr. Brathwaite then said, any current SHB applications would and will therefore fall for consideration under a redesigned SHB package whose details and contents are presently unclear. Given the lack of clarity, the Council put in place the current moratorium. So pausing there, it's clear from this letter that Dr. Brathwaite is then saying that the existing, the incumbents, if you like, would have their application considered under a redesigned SHB application. He continues, the Council has, however, no objection to making exceptions to the moratorium in appropriate cases. Given that your client's application was received on the 6th of March, the same day as the moratorium was announced, the Council is happy to make an exception here. Your client's application will therefore be considered for approval in accordance with the policy. And then in my submission, the last paragraph is a crucial paragraph in terms of understanding the case that Dr. Soares makes. And he says, given the normal time limit for making an application is 1st of July, if your clients have any further information which they wish to put forward in support of their application, they are free to do so up until that date. Any such further information will be added to the current application. And so Dr. Brathwaite is saying in that letter on the 4th of April 2019, in the context of Dr. Soares having challenged by a first appeal the moratorium, Dr. Brathwaite is saying, is inviting further material from Dr. Soares up until the 1st of July, which of course is what has happened. I've already taken you to the letter of the 27th of June 2019, which is the next page, C49, and that is his application. So Dr. Soares accepted that invitation to provide further information. But in my submission, the fact that Dr. Brathwaite is referring to the 1st of July 2019 is significant because, as you've seen already, and I'll take you back to this point, the position is, of course, that is the deadline for the making of full year applications.
Can I just try and establish, Mr. Robinson, what was in the initial application which we haven't seen? Because in the second or third iteration of that application, which is the document that starts at C49, on C55, there is an entire section which is headed mid-year approval. Do you see that?
I see that, yes. Yes.
Yeah. So my question is whether the application that Dr. Soares made initially on the 6th of March, did that contain a similar section?
I'm afraid, my lord, I'll have to check that point because that was not considered by the first instance decision, and it's not in the appeal record. There was never any debate before the judge about what the content was of the previous iterations of Dr. Soares' application.
Well, it must be a mid-year approval, mustn't it? Because it was too late.
No, I'm not trying to resile from the fact that it does ask for a mid-year approval. And of course, if he had made in his application on the 6th of March, even more so because we're further back into the year.
Right.
And I'm going to take you to that chronology in terms of the time limits for each of the applications, because in my submission, one thing which hasn't been dealt with by my learned friend in his submissions, and he may correct me, is that when the Health Council decided and communicated its decision to Dr. Soares on the 22nd of January 2020, there were only 69 days left in what could be considered a mid-year application.
Sorry, can we just say, let's wait until we get to the 22nd of January. Let's look at the position as at the end of June. You've drawn our attention to the last paragraph on page C47, saying, given the normal time limit for making an application is 1 July, if your clients have any further information which they wish to put forward, they're free to do so until that date. But it then says any such further information will be added to the current application.
Yeah, yes, that's quite correct. But what in fact happened was that Dr. Soares updated his application in May, but then resubmitted it in June. And the resubmission in June was everything he wanted the Health Council to consider.
Right.
So in fact, it's not piecemeal. It's not, here's my first one, here's another bit. That may be the case, but on the 27th of June, he submitted a complete application.
Yes, but what he could, if one hadn't got the last sentence on page C47, one might have been thinking that what the Health Council was said was you can make a full year application, provided you do so before the 1st of July. What in fact they said was that any such further information will be added to the current application. The current application was a mid-year application, and as if to make it apparent that that was what was going on, when the final application came to be made in June, it was an application for mid-year approval.
Yes, no, I accept that. And I've taken you to page C87, which is the following day, the 28th of June. And in that letter, what Dr. Soares is, please, in the second paragraph, please find and enclose updated application, which should replace that submitted to you on the 28th of May. So the point I'm trying to deal with is that while I fully accept that the application made on the 27th of June is framed as a mid-year application, it's not necessary to go back to look at the earlier iterations because they replaced this application. But I fully accept it. Of course, as my Lord Bell points out, it's clearly stated on page C55 that it seeks mid-year approval.
Yes.
But what I wanted then to ask you to look at was on page C56, which is the conclusion of Dr. Soares' cover letter with his application.
Just a moment. Yes.
And 2 paragraphs up from the end, he says, it is therefore requested that this application be considered as mid-year and for immediate eligibility for SHB coverage. And then the final paragraph reads, additionally, given the recent and likely ongoing changes with regard to SHB structure and financing, It is also requested that this application be considered as an application to any such equivalent classification that may supersede the SHB system in the future. So I've taken you to the April letter from Dr. Brathwaite, in which he anticipates that by the 1st of April 2020, the new system will be up and running. And in Dr. Soares' application, which I fully accept is framed as a mid-year application, in his covering letter in the last paragraph, he also says, please take this as an application for anything that replaces the SHB system, which, as we know, Dr. Brathwaite has indicated he hoped would be in place by the 1st of April 2020.
I'm afraid I find this paragraph rather opaque. It's also requested that this application be considered as an application to any such equivalent classification that may supersede the SHB system. What is, what is the antecedent to such equivalent classification?
Well, I mean, I've taken you to page C47, which is Dr. Brathwaite's letter of the 4th of April. In the fourth paragraph of that letter, he says, and if you have that to hand, yes. The Minister of Health is currently undertaking a wide-ranging review of SHB coverage as part of ongoing health financing reform initiatives. And in light of policy objectives for universal coverage, it is anticipated that the fully redesigned SHB package of services will be announced later this year to commence on the 1st of April 2020. So there's obviously a process of reform ongoing, and the Council has announced the moratorium of new SHB applications, and therefore I say that the final paragraph of Dr. Soares' application letter, the 27th of June, is simply a reference to the fact that it's anticipated that the system will undergo reform, and that his application should be considered as an application also for anything which, of course, he does not yet know what the reform will be, but which may then come into force in due course.
And nothing has come into force?
Nothing has come into force.
Right. Okay. Thank you.
But if so, having made that point that his application is made, it's a reactive application to the moratorium announcement. It's then made up to on the 27th of June. If I could ask you then to turn to the SHB guide, which is at the very start of the C bundle. And in particular, if I could ask you to turn to page, I think it's a page which in my bundle doesn't have a page number. It's between C6 and C7. I think Mr. Adamson referred to it as C6A and C6B.
Yeah, it's marked as C6A in mine and 6B.
Yes. So as you will see in the application guide, it's what I think you have is C6B. You've got the application process at point 8, review process. 8.1, application must be made prior to July of each year for consideration for approval for 1st of April the following year, i.e. completed applications and all accompanying documentation must be submitted by the 1st of July 2018 to be considered for addition to SHB for the 1st of April 2019. And then 8.2, applications may be considered mid-year if documented evidence that they will not have a negative impact on the cost of SHB standard premium rate, SPR loss ratios. 2, will reduce cost to the system. 3, will not impact utilization of SHB. So of course, those are the two now famous criteria, which are referred to as the full year and the mid-year 8.1 being full year and 8.2 being mid-year. But in my submission, the court should also have regard to 8.3 and the timetable which is there set out for the consideration of applications. Now this table and the timetable can only be logically relating to full year applications. This can only relate to 8.1 applications. And you'll see in 8.3, applications are received and reviewed for completeness. Incomplete applications will not be considered 15th of July. So we've got the 1st of July being the submission date. 15th of July, applications reviewed. 8.3b, HTR, health technology reviews. I know there are obviously various different names given to that committee, but often referred to as the technology committee. HTR will be conducted for new services, technologies, or potential risks to the health system. HTRC will blindly review applications. And note the word blindly in 8.3b. There's no indication that any of Dr. Soares' applications were considered blindly.
Well, they weren't applications for new services, were they?
Well, but if you read on, my lord, in that same paragraph, blindly review applications and access the system capacity for the proposed benefit. HTRC written recommendations will be forwarded to the SRC for review. Then there's the word some with nothing that follows. But sorry, if you read on to 8.3c, SRCs will blindly access all applications, assess all applications, applying the APEX methodology, Appendix 3 and 4, based on objective evaluation and any HTRC assessments. The committee will determine in principle which proposed benefits and provider approvals. So that's where this relates to new applicants. Will be sent for actuarial pricing. So 8.3b and c is not simply relating to the approval of new services, but also the approval of new providers. Will be sent for actuarial pricing 15th of September.
Who is SRC? Is that what that's what I've otherwise known as the SHB Review Committee?
Yes.
Yes.
Yes. If you look over at page C4 at 4.0, SHB Review Committee, then in open brackets SRC.
Yes.
So I think it's what we've been referring to as the SHB Committee in this hearing. So 8.3b and c are effectively the review which Dr. Soares' application went through. The technology committee, we can put it that way, and the SHB committee in C. So for a full year application, we have the application date 1st of July, applications reviewed for completeness in July, a blind review by the technology committee by the 31st of August, blind review by the SRB committee by the 15th of September.
Just pausing there, we know that in fact there was a review by the, I'm going to call it the technical committee and the SHB of the current application. In fact, as you drew attention, 8.3b refers to a review for new services as opposed to new providers of old services. But I suppose that doesn't matter. I mean, what in fact happened was that the technical committee looked at Dr. Soares as a new provider of an old service.
Yes, that's right. I mean, that's what Lula's application was for. It was for the provision of an existing benefit.
I know.
I know. Of a new benefit. But I agree with that 8.3 doesn't, on its terms, refer to applications for new providers of existing benefits, whereas 8.3c does seem to have that reference and provide.
Okay, yes, fine.
But the reason why I'm going through this is because this is the timetable for the annual review of existing, effectively the annual review for full year applications rather. So we have by the 15th of September both of those provisions, both of those reviews by the technical committee and the SHB committee, both having been carried out. And then if you bear with me to the top of the following page, which is C7.
Just before you do, Mr. Robinson, the last words in C are that the application will be sent for actuarial pricing, which is a feature of a full year application and not something which ever happened in relation to Dr. Soares' application, did it?
As far as one can tell from the papers, that never happened in respect of Dr. Soares' application.
No.
There was any actuarial pricing in respect of his application.
No, there wasn't, because it was treated as a mid-year application.
Yes, but that's correct. But at the same time that Dr. Soares' application is going through his review by the Health Council, existing providers ought to have had their full year applications in by the 1st of July, and they ought to have been going through this.
But
process.
they weren't, because there was a moratorium in relation to considering the position of incumbent providers.
Well, that's in practice what has happened, but that's not what, in my respectful submission, that's not what the guidance provides for.
No, it doesn't, because what the moratorium was imposed after the guidance had been written.
Yes, no, I fully follow that, my lord. But the guidance provides that applications will go through. Existing providers will go through an annual approval process. And so the point which I'm going to come on to is that the fact that there was no change in the budget, that there was no new funds coming in because the SPR had been frozen, doesn't mean that the review process by the council ought not to have included existing providers, because the only thing that's happening in the system by the SPR being frozen is that the amount of money in the system is the same year on year. But as I will endeavour to show you, contrary to my learned friend's submissions and contrary to his skeleton argument, the issue, the guidance and the system doesn't anticipate annual reviews being frozen just because price doesn't change, because it's not the review of existing providers provided for in the guidance is not one simply based upon price. The council doesn't say we had approved providers last year and they cost X, and therefore we're simply going to roll them over for another year because we've only got X in terms of money, because the SHP guide doesn't just deal with the financial aspects of the system, it also deals with issues of quality and innovation and all of those things that Dr. Soares says his application brings to the table. I'm jumping rather ahead of myself in my... Okay,
no, don't jump ahead of yourself. I can only take one thing at a time.
That's why I say this is relevant.
Yes, okay.
If I could just continue through this table, I know, sorry, it's taking a little bit of time, but you'll see in 8.3c where I've got to, you've got the technology review, we've got the review by the SHB committee. Then we've got applicants will be notified of their outcome. I fully accept my Lord Bell's point that it provides for actuarial pricing. Top of page C7 in D, following the actuarial review, which we know didn't happen, the SRC will agree to forward options for new benefit approvals to the Minister, including the recommendations for an individual benefit impacts to the SPR. Or, so this is by the 31st of October, or following the actuarial review, the SRC will agree on so this is the relevant provision, will agree on which providers to approve for provision of an existing benefit by the 31st of October. And then following that, applicants will be notified of their application status at this stage. And then the following steps are E, benefit changes, an SPR is approved by the Minister. Insurers are advised of changes to the SHB and the list of approved providers 31st of December. SPR changes are approved by the legislature 31st of March. We know that didn't happen in this year. And then G, SHB fee schedules are updated to reflect changes in benefits and approved providers by the 1st of April. So the full year application process is set out in 8.3, and it goes through these stages in terms of approval, both of the existing, we would say any existing providers, but also any new applicants for full year approval. This is the timetable that ought to have been gone through. But of course, when one looks at Dr. Soares' application and the way in which it was treated by the Health Council, as I've already submitted to you, it was made on the 1st of July, and it was clearly framed as a mid-year approval. But the time scale, sorry, my Lord.
Yes, sorry, it was framed as a mid-year approval. Yeah.
But the time scale in which it was considered was that the technology committee, we call it that, met on the 5th of December. And for present purposes, you don't need to turn this up, but the reference is C89 is the technical committee review. And then the SHB committee, which is C99, was the 18th of December. And then Dr. Soares is notified of the decision on the 22nd of January 2020, which is at C101. And so by the time the Health Council had considered Dr. Soares' application, we're already the only part of that application which could have been a mid-year application was for the period of the 1st of July 2019 to the 31st of March 2020, because the next full year starts on the 1st of April 2020.
I'm sorry, say that again more slowly.
So Dr. Soares makes his application on the 1st of July, he makes it on the 27th of June 2019. And he frames it, I fully accept, as a mid-year application. Now, I've shown you in the SHB guide at 8.3 the timetable through which a full year application should be reviewed by the Health Council.
So we're agreed that's not relevant for Dr. Soares' application.
Well, we say, of course, that existing providers ought to be going through that process.
Existing providers is with respect to another issue. Looking at Dr. Soares' application, 8.3 does not apply to Dr. Soares' application.
No, my Lord, I accept that. But I draw attention to this because the timetable at 8.3 is to be compared with what actually happened to Dr. Soares' application,
right,
which is a mid-year application. And I've shown you where he says in his application, please treat this for immediate approval. Now, we know, of course, that the health centre was not completed till January 2021. It was overly optimistic to be seeking approval for this because of course, the new centre was not open by the 1st of April 2020. But the point I'm making is that the council considered this application, they say, as a mid-year application only, but they did so on a timetable which is much more elongated than for an application, for a full year application had it been made on the 1st of July 2019. And when they decided the application on by the decision letter, which is the 22nd of January 2020, and there are only 69 days left in 2020 between the decision letter on the 22nd of January and the start of the new year on the 1st of April 2020. And so this goes to the point which learned judge made in his judgment, in which he said that if this had only been a mid-year application and filed by Dr. Soares before the 1st of July 2019, Dr. Soares would have had to file another application by the same deadline for the year 2020 to 2021.
No doubt, Dr. Soares correctly or anticipated that his mid-year application would be dealt with a great deal more promptly than happened in the event.
Yes, but it goes, or with respect, it goes further than that, because if Dr. Soares' application had simply been, or put it this way, I can put it slightly differently. If it had been rational, we say it was not rational for the Health Council to consider this application as purely as a mid-year application in the context in which it was made, because it's made 3 days before the deadline for full year applications to be made.
The problem with that, Mr. Robinson, is that your client and your firm treated this as a mid-year application, and they did so even after the application had been reached by the Health Council Committee. When the Health Council advised Dr. Soares that his application had been unsuccessful at C101, they say in the first line, the Health Council has considered your application for mid-year approval. So that's what they say they were dealing with. And when your firm then said, we've received the decision in their letter of 6th of February at C103, they refer in line 3 to, quote, refusing our client's application for mid-year approval. So Dr. Soares and you viewed it, quite rightly, as it seems to me, as an application for mid-year approval.
Yes, Lord. Sorry, I accept that. But what I'll come on to draw your attention to is that in Dr. Soares' grounds for appeal, which were filed on a few days later after that letter, on the 11th of February 2020, and
yes,
they start in the bundle at C108.
And in line 3, it refers to the application for mid-year approval.
Yes, it does, my lord. But if you could please turn to C113 in paragraph 25.
Yes.
Which reads, further and to the extent that the decision has been made on the basis that the application was a mid-year application.
Sorry, you're looking at paragraph 25?
Sorry, my lord, 25,
yes.
On C113. Further and to the extent the decision has been made on the basis that the application was a mid-year application only, the respondent has made the decision on the basis of an error of law and or failed to take into consideration a relevant consideration, in particular the fact that the application was filed before the 1st of July 2019, which would qualify it for consideration by the respondent for mid-year approval, as well as for SHB approval for the 1st of April 2020 per section 8.18.2.
Well, yes, that appears to indicate it was a mid-year application, but you could have made it a full-year application, but didn't.
Well, I fully accept, my lord, that it's framed as a mid-year application. I can't resile from that because it says it on the face of the application that it's a mid-year application. But the point that the learned judge was with us on in argument was that it was irrational for the Health Council to treat it only as a mid-year application. Because, because as I've been endeavouring to submit in the context of the timetable for applications, when the Health Council considered the application, first of all, I've drawn your attention firstly to Dr. Soares' own application papers in which he asked that the application be considered for anything that came after the current system. Now, we know that nothing came after the current system, but the point is, my lord, that if this had simply been a mid-year application, it would only have been for the period up until the 1st of April 2020.
But that may be, but it doesn't change the nature of the application.
Well, my lord, it doesn't change what how the application was framed, but in my submission, it changes the situation of, or the basis upon which the Health Council ought to have considered it. Because the Health Council's deadline for full year applications is the 1st of July. Had Dr. Soares simply intended this application to cover the period from, let's say, the 1st of July 2019 to the 31st of March 2020, and not be for the period from the 1st of April 2020 to the 31st of March 2021, he would have had to have filed exactly the same applications, because there's no further application deadline, which he is then going to meet for his full year application. Because he would have, and the learned judge makes this point and makes this finding that it was irrational for the Health Council to treat this as a full year application, or the Health Council to treat this as a mid-year application only for this very reason, which is that
But I mean, how can you blame the Health Council for treating the application in the manner that it was expressed to be? And to say it was irrational not to do so seems to me even more of a stretch.
Well, my lord, I do submit that it was irrational for the Health Council to do that, because the Health Council would have treated the application as a mid-year application only in a context in which the application was considered in a very delayed fashion and was considered almost at the end of the only period during which it could have been a mid-year application.
Right.
But whether or not rightly or wrongly, and whether or not Dr. Soares could be criticized for this, he didn't file two copies of the same application, or he didn't file prior to the 1st of July 2019. He didn't file a mid-year application and a full year application. The point I'm making is that there's a missing year here.
Well, I fully understand that the process moved more slowly, but if Dr. Soares, because of the snail's pace at which the process was proceeding, if he had said, look, this is getting pointless for a mid-year application, I need you to treat my application as a full year application, it's incumbent upon him to say so.
Well, he didn't say that, my lord, but we did say that in our appeal grounds, which of course are the appeal grounds which then were considered by...
But your appeal grounds were drafted on the basis that it was a mid-year application.
Well, they were drafted on that basis, my lord, because that's the way in which they were...
Because that's the reality of it. That's why they were drafted that way.
That's the way in which they were framed. But my lord, we also, in our appeal grounds, asked the appeal tribunal to consider the application, to consider the point that it was irrational for the Health Council to consider the application solely as a mid-year application.
Well, we get ever more complicated. The application was made as a mid-year application, and the notice of appeal accurately referred to it as a mid-year application. You say that despite the fact that Dr. Soares didn't say, please treat it as a full year application, it was irrational of the Health Council to treat it as what it was said to be. That may require some persuasion of us. But also there's an additional problem, because the full year application requires more extensive consideration than the mid-year application. That is to say, the actuarial assessment that the system calls for. It can't be any good after you have failed in December 2019 on your mid-year application, then to invite the appellate committee to decide the question as if it was a full year application in circumstances where the procedure called for by the first full year application has not been followed because the application was a mid-year application.
Well, Lord, I would accept that if it weren't for the crucial fact that the Health Council simply rolled over incumbent providers without any consideration of why they should be continued into a further year.
That with respect, is a separate issue, isn't it?
Well, it's a separate issue, but it goes to the issue of rationality of how they treated Dr. Soares' application, because we can't look, in my submission, the court ought not to look at Dr. Soares' application in isolation from what's happening to the existing providers. So and I fully accept, and of course I must accept that there's no new funding coming into the system because the SPR is not being rebased. So I accept that there's a finite amount of money in the system. But in my submission, the court ought not to look at these issues of how this application was framed and the timetable of the application in isolation from what's happening to the existing providers who are simply rolled over, because there's no consideration given to their applications whatsoever.
Well, I understand that you say the incumbent providers have been unfairly favoured, but just assume that for the moment. assume that there shouldn't have been a moratorium in relation to the incumbent providers, that still creates the problem that whether with or without, whether including or not including the incumbent providers, no actuarial assessment has been made in respect of Dr. Soares' application.
Well, that's quite correct, Lord. As far as one can tell, no actuarial assessment was made in respect of Dr. Soares' application. But nor was there any actuarial assessment made in respect of the existing providers.
I follow that, but I mean, so what?
Well,
I mean, you could, I suppose, have brought a judicial review saying all the approvals in relation to the incumbent providers should be set aside, but we're not there.
Yes, my Lord, but the point is that notwithstanding that there's no new funding into the system, the Health Council didn't, as far as we can tell from the papers and what was submitted to the judge in the evidence, the Health Council didn't undertake any actuarial analysis of any application. Now, the proposition seems to be put forward by my learned friend that that's entirely irrational because there's no new funding. But my submission, that's completely wrong, because the fact that there's no new funding coming into the system doesn't mean that the Health Council can't undertake actuarial analysis of the existing providers and any new application for a new provider.
Yeah, you say there should be an actuarial analysis of the incumbent providers and all other putative providers. There wasn't, in fact, an actuarial analysis of any of them.
Yes, that's right, my Lord.
Right. Well, that means that there hasn't been the necessary consideration either of your client or of any of the others.
Yes, I accept that, my Lord. But the point which I'm trying to develop and will try and further develop is that the SHB guide and the assessment of providers onto the guide is not simply, of course, it's not simply based upon price. So the actuarial analysis.
Let's assume that in your favour. Assume that to be so. We ever return to the fact that you say there should have been an actuarial assessment, even though there was no change in the premium coming in respect of all providers, incumbent or future. Assume you're right about that.
Yes, Lord.
Fact of the matter is that your client, who asked for a mid-year approval, did not seek in terms of full-year approval, has never been in circumstances where there's an actuarial assessment that has extended to him.
Well, I accept that, my Lord, but I don't accept that results in the rationality of the Health Council's decision being it being a rational decision, because none of that is within Dr. Soares' his gift. The fact that
wait a minute, just pause for a moment. Making an actuarial assessment is not within his gift, but he could have applied for a full year assessment and didn't.
Yes, he could have applied. He could, on the 1st of July 2019, filed a second set of papers, which would have been, in my submission, apart from being framed as a mid-year application, would have been exactly the same as the application which he did in fact provide.
That would make it easy for him.
I'm sorry, my Lord?
That would make it easy for him.
Well, it would mean we wouldn't be having this debate today as to whether or not it's framed as a mid-year or a full-year application. But of course, when one looks at his application, he sets out in detail why, as a matter of quality, his health centre is top line. It has got new equipment. It's got provision which, on terms of quality and patient choice, is much better than anything else that's on the market. He provides billing codes, and he provides a breakdown of that which he says his centre might well use. And he says he does that because Dr. Brathwaite, and I don't want to get into this debate because it's not a productive debate, he says Dr. Brathwaite either told him or advised him that that's how he should frame his application. That's not already before the court, but that's what he did. And he did that on the basis of a mid-year application in my submission, which he files before the 1st of July 2019. But it makes no logical sense in my submission. I'll come back to the issue of actuarial analysis. It makes no logical sense for the Health Council simply to treat that as a mid-year application, because it must have been clear, it ought to have been clear to them that he wasn't simply making that application as a mid-year application, because otherwise he would have had to file a second application on exactly the same day for the following period of the 1st of April 2020 to the 31st of March 2021.
Right.
And the judge, if I could ask you, my lord, and my lords and ladies, to look at the judge's ruling in paragraph 103, and that's at A52 of the hearing bundle. I'm sorry, do you have that?
Yes, I have, yes.
So 103, he says, first, the timing of the application and the subsequent submissions had all the hallmarks of a full year application. I accept the factors submitted by the applicants as reasons why the application should have been treated as a full year application. In March 2019, the mid-year application, if successful, would only have been for a limited period of time, that is March 2019 to April 2019. Now, pausing there, my lord, lords, my lady, that's not, I accept that that's not correct.
No, because
it wasn't the case that Dr. Soares is filing his application in March just for a month. He's clearly filing it for the following year.
because the substantive application that was considered was dated 27th June.
Yes, of course. So I accept that that's an error.
And the judge seems to have missed that.
He seems, yes, I'll just follow on, my lord, for two further sentences, because he hasn't missed the substance of the point that I'm making. He says, in my mind, it is inconceivable that the applicants were applying for that short period of time, having made considerable investment in their business premises. If that were the case, then they would have been required to submit another application by the 1st of July 2019 for a full year application. So that's the point I'm making, which is that—
Yes, but that short period of time which the judge is referring to is the misconceived 2 months.
Well, yes, but the point I'm making is that, as I submitted, is that when the mid-year application was considered by the Health Council and decided by them by the 22nd of January, the only mid-year period left was a very short period of just over 2 months. And so the judge in that sentence, which I've just opened to you, that if that were the case, he would have been required to submit another application for a full year application. While the judge has got the dates wrong in the previous passage of the judgment.
And there's a rather different time period that runs.
In my submission, he's completely right about that point, that if it were the case that this was only a mid-year application, Dr. Soares would have been obliged to submit a second application on the 1st of July 2019 for the full year that runs from the 1st of April 2020 to the 31st of March 2021. And so the court in my submission shouldn't be confused by the fact that Dr. Soares made a second application, because Dr. Soares made a second application for the year which he made his second application at the end of June 2020, and that was for the year.
All right. Now we're talking the full year application here.
Yes, my lord.
He didn't make the full year application until a year later.
He made the full year application at the end of June 2020 for the full year, 1st of April 2021 to the 31st of March 2022.
Right.
So, sorry, my lord.
Well, that gives rise to another problem. Be it assumed that you are completely right, and that despite the terms of the application, the Health Council acted irrationally in not treating it as a full year application. The best that could be would be that it should have treated it as a full year application from the 1st of July 2019. It should have been treated as an application made in June 2019 in the time limit for a full year application for the year 2020 to 2021.
Yes, that's correct.
Right. Be it assumed that all of that is correct. So they should have considered it as a 2020/21 year application, an application in relation to that year. We are now in the year 2021 to 2022.
Yes, my lord, I accept that. But when the judge heard the judicial review in February 2021, we weren't in that new year. Now, he didn't give his judgment till the 8th of April, of course.
Yes, and what he's ordained, effectively, is that there's approval for 2021 to 2022.
Well, he didn't say that, my lord. He just simply granted approval.
I know he didn't say that, but if you that's hence my questions on Friday as to what the effect of his order was. And the effect of his order is that the approval has been given for the year 2021 to 2022, a year in relation to which no application has ever been made, and in relation to which, in consequence of no application ever having been made, no actuarial assessment has ever been made.
Well, Maura, I'll come back to actuarial assessment again, but the point, of course, was the point which I'm making is that the application for judicial review was in early February 2021. The judge didn't give his ruling until the 8th of April 2021, and I accept he didn't frame that in any particular way as to when that application was heard for. But what he did very importantly say in his ruling, and I'll come on to this at the end of my submissions, what he did say in his ruling was it was open to the Health Council thereafter to run a full year application for all providers. So this proposition that the judge has given Dr. Soares an approval which is set in stone and can't be changed is wrong, because the judge anticipated that the Health Council would then be able to run a full year application process on a fair basis for all providers.
Let us assume that the judge, instead of giving his judgment on the 3rd of April, when was the hearing in front of him?
The hearing was in early February. It's on page.
Right. Assume that with remarkable speed, he had given his judgment on the 1st of March.
Yes, my lord.
All he could have ordered, on the assumption that you're correct in relation to everything that you have said, is that the Health Council should have treated the application as a full year application and should have granted it. Despite should have granted it. That would mean that Dr. Soares was entitled to be put in the position as if he had been granted an application from April 20 to April 21.
Yes, my lord. But my response to that is that Dr. Soares, as I just recently submitted, has filed a full year application for the year that started on the 1st of April 2021.
I know, but it hasn't been determined.
But yeah, my lord, that's quite right. But the timetable that I've just taken you to, and I know I must deal with the issue of incumbent providers, but the timetable that I've just taken you to anticipates that full year applications will be considered in time for approval by the 1st of April of the next year. And so to say the judge has given Dr. Soares approval for the wrong year overlooks the fact that he's made an application for the right year, if you like, which is
it doesn't overlook that at all, because the fact that he wisely made an application for the right year means that if that application hadn't been stayed or agreed not to be proceeded with, he could have got an answer for the right year.
Lord, there was no agreement to stay or not proceed with that application. Dr. Soares was pressing for that application to be considered.
Right, okay.
That correspondence is in the papers, which I will take you to.
Okay.
He was pressing for that application to be considered.
For the full year application.
Full year application for the year starting April 2021.
Right. And that's the application which has not been dealt with, which is the full year application. I think we've gone over why it seems strange for the judge to have treated the mid-year application as a full year one.
Well, my lord, the submission which I was making, sorry if I'm jumping around, but the submission I was making was that just to summarize that point, and I don't necessarily need to go back over it, but the application which Dr. Soares made at the end of June 2019, in my submission, it was quite right for the judge to hold that it was irrational for the Health Council to treat that as a purely as a mid-year application because of this point that otherwise there would be a missing year in his application. It wasn't rational for the Health Council simply to treat this as an application which was going to cover effectively those 69 days in 20.
I don't follow the rationality, but I've already said that. And Mr. Robinson, when you were addressing the second appeal tribunal in September 2020, you made the comment, and it's at C186, that this application was always a full year application. That simply isn't so, is it?
Sorry, no, which page is that again?
C186, the bottom 3 lines.
Well, I think I'm making the same point in those submissions, my lord, as
Yes, but you're also trying to rewrite history because, well, it's not a question of how many days were left. You said it was always a full year application. I'm suggesting to you that that's quite wrong.
Well, I said, my lord, I said in those submissions at the top of page C187, it was submitted prior to the 1st of July deadline for the full year applications. I'm not able, of course, to take back what I said in that hearing, but no. I'm submitting that.
But you could acknowledge that it was wrong.
I'm making the same point, my lord.
You're not prepared to acknowledge that it was wrong.
I'm fully prepared to accept, Lord, as I have this morning, that as the application was framed, it was framed as a mid-year application. We've looked at that as part of Dr. Soares' letter.
Right.
What I've taken the court to this morning is also the grounds for appeal in February 2020, in which paragraph 25, the application which the appeal tribunal considered, and our submission was that the council ought to have considered it as a full year application. And if
that's a little hard to sustain when your appeal refers in terms to the fact that it was Dr. Soares' mid-year application which was being considered.
Well, I think, my lord, the position is that the appeal was run on the basis that Dr. Soares had fulfilled the mid-year criteria, and so of course for the year up to the end of March 2020, it was a mid-year application, but the submission was that the council ought, which is the same submission I make this morning, the submission was the council ought also to have considered it as a full year application.
But that was the parallel full year application. Is that what you're referring to?
No, my lady, that's the point which I'm the point which I'm trying to highlight, which was that the full year application that Dr. Soares made, he made it at the end of June 2020 for the year that started on the 1st of April 2021. So there's no parallel full year application. I accept that on paper, the application made by Dr. Soares was a mid-year application, and I accept that on his papers, it was not framed as an application for the year that started the 1st of April 2020 to the 31st of March 2021. The submission is that the Health Council was irrational not to treat it as such.
Right, but when you were appealing the Health Council's decision, you said this is an appeal against the decision of the Bermuda Health Council refusing Dr. Soares' application for mid-year approval. I mean, that's at C108.
Yes, my lord, I fully accept that the grounds of appeal and the hearing of both appeals, proposition was put forward that Dr. Soares had fulfilled the mid-year criteria and the mid-year application ought to have been successful. But the point I also make is that in our written submissions and our oral submissions before both appeal tribunals, the submission was also made that the Health Council ought to have considered the application on a full year basis. But I don't resile from the proposition or try to rewrite history that we didn't run both appeals on the basis that it was a mid-year application, firstly, that ought to have been approved for the mid-year application, but that it also ought to have been treated as a full year application.
No, but the full year application is completely separate. and has not been considered.
No, my lord, the full year application is not for that year. The full year application was made at the end of June 2020.
Correct.
For the year that started the 1st of April 2021.
There was no full year application.
So there was no full year application submitted by the 31st of or the 30th of June 2019 for the year that started the 1st of April 2020.
Right.
The full year application wasn't submitted till the end of June 2020 for the following year.
For the following year, right.
So it goes back to the same point, which is that when the Health Council was considering Dr. Store's application, dated the 27th of June 2019, I fully accept it was framed as a full year application. I fully accept that both appeals were run on the basis, as a mid-year application. I fully accept that both appeals were run on the basis that the mid-year application ought to have been granted. But the second point is that the Health Council, we say, ought also, and which the judge agreed with us, was that the Health Council ought also to consider that application as an application for the full year, which ran from the 1st of April 2020 to the 31st of March 2021.
But the Health Council did consider the argument which you had raised in September, that it had been always should be treated as a full year application. If you go to C254,
yes, Lord.
There's the biggest section in the middle of the page is deliberation mid-year versus full year. And it starts, the members of the committee discussed the argument presented by Dr. Soares regarding the contention that the application should be now considered for full year approval.
Yes,
Could you just tell me what page you're on? Sorry, I missed it.
C254.
Thank you.
And it carries on, 2.3. The Health Council has responsibility for opining and making decisions in relation to risks, to the budget, and the value that a new entrant to the market can provide in a better and more cost-effective product to the market. And it carries on in 2.4. As the SPR has remained static, there is a requirement for sufficient evidence to be presented to demonstrate the continued integrity of the SPR budget. Full year applications inherently are aligned to changes in the SPR made by the Minister of Health. As such, this application would still be considered a mid-year application and not a full year application. So you can't say that they didn't consider it. They did consider it and they rejected your argument.
Yes, my lord, I accept that, but they rejected the argument because for a number of reasons, but the crucial reason is that the SPR had not been rebased.
Well, the whole point about a full year application is that one has to go through the actuarial process so that one can consider properly the impact of the new provider on the budget.
Well, my lord, that's a point which I was going to come on to, and I'm happy to deal with it. Happy to deal with it now. But learned friend and the Health Council make much of the actuarial analysis that's required to each year.
Sorry, just before we get to the actuarial analysis, you say that the appeal committee, appel panel, should have treated the application as a full year application, really, because in the events which had happened, a large amount of time had passed since the decision was originally made. But the decision made in December 2019 and announced in January 2020, in front of the people who decided that decision, it was never suggested to them, was it, that the application should be treated as a full year application?
No, my lord. I've taken you to the portions of Dr. Soares' cover letter in which he says, yes, it's a mid-year application. Please also consider it for any revised SHB system that comes thereafter. No, yeah, I accept that there was no articulation before our appeal papers in February 2020 that it ought to have been considered as a full year application.
But even if that's right, how can the appeal committee be in error for not doing something which the original committee hadn't been invited to do either?
Well, because, my lord, we said that it was irrational for the original committee not to do that, given that.
But they were never asked to do it.
Given the timescale. So there's 2 points, my lord. First of all, it's given the timescale during which the application is being considered. They're considering it at the end of, they're apparently considering a mid-year application at the end of December, which is later than they would have been considering a full year application. And then they don't give a decision till January.
The answer to which is that it was incumbent upon Dr. Soares to say, look, this process has dragged on for far too long. Please treat my mid-year application as a full year application. And he didn't do that.
That articulation of the position was not made until the appeal grounds were filed in February. But what I'm endeavouring to argue and to explain is that the timetable under which the application was considered, apparently by the council as a mid-year application, was much slower than the timetable which the council ought to have been considering full year applications. And we submit that had the council treated this on a rational basis, it would have been obvious to them to treat it also as a full year application, because of course Dr. Soares wasn't just making the application for the period until the end of March 2020, because otherwise he would have had to file a second application on the same day.
I think we've had that point.
I have made that point before, my lord, but I'm simply endeavouring to cover off the questions.
So what it amounts to is that because the first instance tribunal had taken rather a long time to reach its decision, such that there wasn't much left if an application was treated as a mid-year application. It should, not having been invited to do so, have treated it as a full year application. And it was irrational of it not to, and it was irrational of it not to do so.
Well, it was rational, my lord, it was irrational of them not to do so, we say, partly because of the points I've already made in terms of the timetable and the way in which it was submitted. But also, we also submit it was irrational for them to do so, given the way in which they were treating incumbent providers, which is the second major issue. Well, my submission is that we can't look at the way in which the Health Council treated Dr. Soares' application, whether as a mid-year or, as we say, they ought to have done as a full year application in isolation from the way in which they treated the incumbent providers. And in my submission, the way in which they treated the incumbent providers was in clear breach of their own policy, and they simply rolled over the providers on the basis that they were incumbents. They did so ignoring their own guidance and their own policy, which doesn't just look at whether or not the actuarial analysis has been done and whether or not it was able to be done because the SPR hadn't been rebased. So that if that's convenient, I will move on to that point.
Yeah,
I've probably done what I can in terms of the issue of the timing of the application. So, my lords, in terms of what happened to the existing providers, and as is clear from the evidence of Dr. Soares, as referred to on Friday, in respect of CT scans and MRI scans, there is effectively only one other incumbent provider, save that the hospital also, of course, does that testing. So if I could ask you to look at the SHB guide at 6.2.3, which is on page C6.
yes.
And you'll see, my lords and my lady, at C6, 6.2, that SHB has three main goals. And Mr. Adamson went through some of this on Friday, but not all of the paragraphs. But you'll see that there are three headings: access, affordability, and quality. I don't intend to open that all to you, but I draw to your attention that these are the guiding criteria in our submission for the approval for SHB. And in particular, I want to draw to your attention 6.2.3, which deals with quality, which starts, SHB should be delivered by trained health professionals using safe equipment and quality health facilities. The quality of the care provided should not be compromised. Training and implementation of guidelines and or standards in the service provision as outlined by health professional bodies can help to demonstrate quality care delivery. Applicants can voluntarily apply for approval to be reimbursed for SHB services if they provide information about the provision of these services and meet a set of requirements. And then the last sentence is crucial. We say approvals are granted on an annual basis and all providers must reapply annually.
Yes.
And so when one looks over the page, I think it's 6CA in the courts bundle. We have at the very top of the page, approval to provide an existing benefit. And as we know that this is these are existing benefits that Dr. Soares wishes to provide. And at the top of the page, approval to provide an existing benefit during the annual review of SHB benefits may be added or removed. And then the last sentence of that paragraph, appropriately trained health professionals or health facilities can apply to provide one or more of the existing benefits. And then we have on the, if your paper's in color, you'll have two blue boxes at 7.2 and the first blue box deals with certain regulatory approvals which must be provided, and then the second box notes note for the application for approval to provide an existing benefit. Applicants will be asked to provide information about the following. Now, there's nowhere in this guide does it suggest that on the mandatory annual review that existing providers are not obliged to provide the information which is set out in this in the guide. And there are five in my submission. There are five criteria, and it's important to note that the guide does not say that applicants for approval for benefits must prove these matters. What it says is that applicants will be asked to provide information about the following: facility suitability to provide the benefit, a description of the quality controls in place for provision of the benefits and how services are more accessible to the target population, indicators that demonstrate how the service has increased accessibility and the quality of care for patients, 4, whether the applicant currently provides the benefit, presumably being reimbursed through supplemental insurance coverage or patients' out-of-pocket payments, and then 5, the need for additional providers to be approved to provide this benefit. So in my submission, those are the key criteria in terms of the Council's review of applicants to provide an existing benefit. But it is not the case in my submission that these criteria are simply there for applicants who make who are a new provider of an existing benefit. And my learned friend said on Friday that there are no full year criteria. In my submission, that's quite wrong. These are the full year criteria, which in my submission apply to all applicants through the annual run of approvals. Now, I accept, of course, as I must, that the last bullet point appears to be a criteria which is applicable only to new entrants who want to get approval for SHB who don't already have it, because it obviously refers to additional providers. And then if I could ask you then to turn over to C9 in the same bundle, and these are this is the SHB assessment guide, and there are 4 appendices, and I respectfully submit that Appendix 2, 3, and 4 are relevant for the court's consideration. And so if you look at C9 and Appendix 2, this reads SHB assessment guiding principles. And if I could take you down the page to the assessment questions. And we have, it reads, for the application for approval to provide an existing benefit, applicants will be asked to provide information about the following. And then there are 4 bullet points there. They replicate the bullet points on page C6A, except that they don't have a reference to the 3rd bullet point, indicators that demonstrate how the service has increased accessibility and quality care for patients. So there is a difference between the bullet points on the assessment guide and that which is represented in 7.2 in the second box. But I accept, of course, so what's missing from that document is the reference to increased accessibility, quality of care. That criteria is missing from that document. But what is there, of course, is still this criteria, the need for additional providers to be approved to provide this benefit.
Just pausing there for a minute, assume that you have been providing benefits, an existing benefit for a long time. And can you simply put in an application which says the facilities are the same as they were before and remain suitable, the quality controls are the same as they were before. I currently provide that benefit, as you well know. I mean, will that do?
Well, I mean, I'm not saying that they can't cross-reference their previous applications.
Right.
What I am saying is that the council clearly have a policy which requires applicants the providers must reapply annually. And as far as their documentation is concerned, the criteria apply to all providers, whether new applicants or repeat applicants, save for that one issue, which is in both of those documents, the need for additional providers to approve the benefit.
Right.
I'll come on to deal with need in a moment, but if I could just ask you to look over at page C10 and C11. And these are apparently the scoring sheets for SHB assessment scoring instructions. And then the instructions are in Appendix 3 and the scoring sheet is in Appendix 4. And at the top of page C10 at point 1, the rating apparently is rate each SHB proposal on the following criteria. 1, size of the risk to the patient's health, A, importance of the health problem to the community, B, effectiveness of the intervention presented by the proposal, C. And then you have a scoring system set out in 2, number 3, return it to the secretary. And then Appendix 4 is the assessment scoring sheet.
Where's Appendix 4?
Appendix 4 is on page C11. It's just a table. It says at the top, the scoring
Oh, I
sheet.
see. Yes, I see. Yeah.
It was developed by the Health Council to review SHB proposals objectively.
I mean, it's quite difficult to fit Appendix 3 into imaging services. A is the size of the risk to patient health if the condition is not treated. Well, that depends what the condition is, which you don't know until you've carried out the imaging. B, the importance of the health problem to the community. Well, imaging it's not dealing with a specific, well, not really dealing with a specific health problem. It's dealing with the means of discovering what's wrong with somebody. And C, the effectiveness of the intervention presented by the proposal. Well, imaging isn't an intervention, it's a process of discovery. I mean, not that easy to apply these criteria to imaging, but no doubt people can.
I don't disagree about that, Lord. The point I'm taking you to these documents to show is that there is apparently an objective assessment of the applicants who must all apply annually for review of their SHB. But of course, the criteria, the point I highlight is at the 3rd bullet point, effectiveness of the intervention presented by the proposal. So the Health Council in their annual review of applications are not simply concerned with price. I fully accept, of course, that the price and the cost of the system is a relevant consideration. But the proposition being put forward in the appeal appears to be that because the SPR had not been rebased, and because the actuarial analysis, it is said, could not be carried out, that therefore there could be no review of existing SHB providers on a full year basis. And
I thought that was because the minister was intending to make substantial changes to the entire system.
Well, my lord, the fundamental problem put forward by the council in this cycle was that the SPR had not been rebased, and therefore there was no further money.
But wasn't that the reason for it, that the minister was proposing to make major changes?
I understand that. I accept that that's right, that the reason why the SPR had not been rebased is because it was intended to be reformed. But the submission I'm making is that the SHB application process is an application which is partly based upon one relevant criteria, of course, is the issue of price. But when one reads the documentation carefully with respect to the application process, the position is that we have the fundamental principle. We say that the council's proposal guide establishes that there's an annual review of all providers. It clearly states everybody must reapply annually. The criteria which the Health Council goes through in the annual review of SHB providers, that my submission that they ought to go through, is not a review process which is solely or principally based upon price. I accept that price is a criterion, but we've got the guide which says we're going to consider, for example, quality, access to the system, and then we've got these 5 criterion that I have asked you to look at on page C6A, and then we've got scoring sheets which don't then replicate precisely the bullet points which are said to be the criteria, but these reviews are clearly directed at issues including the provision of quality services to the population. Now, I took you earlier on this morning to the guide in 8.3, which indicates that there'll be blind review of both technology and SHB committee. But this documentation clearly indicates that there is the application of the criteria for the SHB approval is looking at more than the money coming into the system. Now, my learned friend, Mr. Adamson, gave you the analogy of a pipe coming into the system. Now, I fully accept that the pipe coming into the system is fixed because there's been no SPR review. And so there's no more money coming in. But I don't accept that means that it was rational for the Health Council not to review existing providers in accordance with the proposal guide and the broader criteria in terms of quality. Now, I haven't taken you to Dr. Soares's letter of application, but well, we've been there briefly. But if I could perhaps take you back to that application letter, and if I could ask you to look at C51.
P61?
C51, Lord.
51.
And he says, under the heading medical imaging, he says, Bermuda patients very much desire alternative options to the hospital and Bermuda Healthcare Services Brown Darrell Clinic, which are currently the only 2 facilities offering MRI and CT scans. Increasingly, the number of options where one can have medical scans and investigations increases competition among providers, ultimately resulting in enhanced quality, better service, and more competitive pricing. The medical quasi-monopolies which currently exist in Bermuda, whereby only a restricted number of facilities are allowed to offer certain services under SHB removes all competitive incentives to provide better and more convenient service at lower prices. There's an erroneous belief held by some that increasing the number of MRI and CT scanners and other components of essential medical testing available on the island would increase utilization. This is contrary to the very tenets of supply and demand and the accepted view of forces acting in the economy. Indeed, utilization will not and cannot increase as long as only medically indicated tests are ordered. If other forces are operating, only if other forces are operating can utilization increase as a result of the addition of facilities. If indeed this has historically been found to occur, it is probable that other incentives might be at work.
So basically what Dr. Soares is saying is that he's submitting that the entry of his facility into the market will actually not increase the overall medical imaging.
Well, he's doing two things, my lord. That's quite right. He's saying there'll be no additional testing because I'll only be tested upon the basis of medical need. But the reason why I took you to this document was also, and I'd be grateful if you would read down to the next heading of equipment, but I wanted to take you to, and I'm not sure you need to do it. I don't need you to do it now unless you wish to, right, that page, but if I could take you to the equipment section. He says, open MRI, Hitachi Oasis XP. The new center will feature Bermuda's only truly open MRI, which, with its unique open architecture and 360-degree views, will afford more comfort to the claustrophobic, anxious patient and will reduce the need to administer potentially harmful sedation. There are currently no truly open MRI systems in Bermuda and only MRIs with a tunnel-like architecture existing in which a patient is enclosed. So he's saying there that his center offers something different in terms of quality because there's just, well, for anybody having an MRI scan, that is better, but also there are some people who can't have MRI scans in that way or that need to have sedation. But if you look at the top of page C53, where he continues that thought in the last paragraph, which is generous proportions, the open MRI also facilitates scanning of obese patients that otherwise would have to be referred overseas for their MRI due to the absence of suitably sized scanners locally. And he makes the same point then, my lords and my lady, in the next section, which I'm not going to read to you, CT scanning. But he also says in his submission in regard of CT scanning that particular type of CT scanner is not available on the island and it's of greater quality. So I take you to these sections of his application. I don't want to take you through all of the application, but I take you to these sections of the application to demonstrate that in our submission, the application did provide to the Health Council information and relevant information about the services that he would be providing, which on a quality assessment would be better than that which is available on the island at the moment. And I do this because of my broader submission, which is that the Health Council, in failing to review the approvals which were provided in the previous cycle, if you like, for incumbents, failed to look at any of those applications on any other basis than to say, because the SBR has not been rebased, and because there's no more money in the system, therefore we're going to roll over all existing providers without any assessment of their applications. Because that's exactly what happened. In my submission, existing providers ought to have filed their applications for approval start for the 1st of April 2020 to the 31st of March 2021 on the 1st of July 2019. And those applications in my submission ought to have been reviewed in accordance with the Health Council's policy, notwithstanding that the SBR had not been rebased and notwithstanding that there's no additional money in the system. Because not to do that applies the criterion of price over all of the other criterion which the council say they're going to apply in these applications in the guide which of course extend also to the issues of quality and patient care. But not only that, not only did they, by ruling over existing providers, did they not consider other criterion apart from price. On the papers before the first instance judge and in my submission before this court, there's no evidence to suggest that the Health Council even considered price in the existing provision of SPR. And this goes to the point raised by my Lord Justice of Appeal Bell with regard to the annual review of the SPR budget and the checklist. And my learned friend in his submissions was very, a number of times submitted to the court that there's an iterative process which relates to the setting of the SPR, or setting of the SPR and the reapplication for SHB approval, and that iterative process didn't take place, couldn't take place because the SPR had not been rebased, and therefore it was not an illogical and irrational decision for the council simply to rule over existing providers. But in my submission, that can't stand up to scrutiny. And if I could ask the court to look at the checklist, which is at page C13. And it goes over to C14. And this is the 40-stage iterative process that my learned friend points to say, well, this process couldn't take place, and therefore SHB, it was quite logical for the Health Council to rule over existing providers. You'll see it at the top of page C13. The heading is checklist for establishing the annual standard premium rate.
Mr. Robinson, would you accept that this is all relevant only if the Health Council should have considered Dr. Saul's application as a full year application?
Lord, I submit that these points are relevant to my arguments as to why it was irrational for them not to have done that.
With respect, you haven't answered my question. Aren't they relevant only if Dr. Saul's application should have been considered as a full year application?
Yes, Nor, I think I would accept that. But this is for these criteria are for the annual review.
So they only arise if we're with you on the mid-year, full year point.
Well, they only arise in that sense, but we submit, my lord, that it was irrational for the council.
No, I think we have that argument.
Okay. Okay, my lord. I'm sorry, my lord, if I've been repeating myself, but I asked you to look at C13 and C14.
Yes, I'm a little puzzled as to the relevance of C13 and 14. They contain a 40-stage process of establishing the annual standard premium rate. Given that the standard premium rate has to be fixed by the minister, and given that the minister said he wasn't going to change it, what is the relevance of a 40-stage process which would be vain to embark upon if the minister was never going to change the premium in the first place?
That's my point, where it's not relevant. The fact that the 40-stage process couldn't be carried out is not relevant. And the reason why I wanted you to look at this document was because you'll see on steps 10, 11, and 12. I mean, steps 10, 11, and 12 of this document appear to relate to the annual review of SHB applicants. You see that 10 reads, receive applications for additions or amendments to SHB and MRF, including codes, utilization, and proposed fees. 11, benefits review committee reviews and recommends benefits to consider for pricing. 12, benefit additions approved for pricing by the council and the Minister for Health. It's very difficult to follow the timings over to the right in terms of due date and revised. But I fully accept that there's an intersection between the usual review of the SPR, which this 40-stage process is aimed at, and the review of SHB approval. But the 40-stage process, and this goes to my the President's point, is that the 40-stage process is the actuarial process with regard to the annual SPR setting. The SPR was not being reset in this cycle, and therefore this 40-stage process is not relevant. But this goes back to my point that that the Health Council have reviewed Dr. Soares' application, that the Health Council have rolled over existing providers because the SPR was not rebased, but it's not. But they haven't looked at any of the other issues which they say they're going to look at in terms of the annual review of SHB providers. And
well, that I follow, but that's a different point. You say price isn't everything, so the fact that the price or the premium isn't everything. So the fact that the premium isn't going to change doesn't mean that you abandon considering other relevant material. And what the Health Council should have done was to consider, in relation to all the incumbent providers, as well as Dr. Soares, the various criteria express or implied in this document, upon the footing that the standard premium rate would be the same.
Yes, Board.
Well, in those circumstances, we don't need to look at the 40-stage process, do we?
Well, I took you to that just to show you that it wasn't what, in my submission, what it's being presented as. It's not the reassessment of SHB providers is not dependent upon the 40-stage iterative process, because the reassessment of SHB providers is said to be an annual process which must be carried out each year. And as I've already submitted, is carried out each year, not simply because the amount of funding coming into the system is changing, but also because there are many other requirements and criteria which the Health Council ought to have been considering. And I say it's noteworthy, my lords and my lady, is that the Dr. Soares only discovered that the annual review had not been carried out very late in the day. And on Friday, Justice of Appeal Milady Gloucester, I think, asked Mr. Adamson when were existing providers told that they were having their applications rolled over. And Mr. Adamson's response to that was in December 2019. But of course, if that begs.
Excuse me, I think I said October 2019, and I've confirmed they were informed in October 29. The decision to roll them over was made just prior to that. So it was October, not if that matters.
Well, it doesn't matter for this point, which I'm making, my lords and my lady, and that is that the applicant, according to the SHB guide, annual review is mandatory. The deadline for annual applications is the 1st of July 2019. There appears to be no decision made in terms of rolling over existing providers until after that deadline is expired. Yet there was no evidence before the judge at first instance as to what had happened to those applications until an exchange of correspondence. If I could briefly take you through this point. I start the point by saying that existing providers ought to have had their approvals applications in by the 1st of July for the year 1st of April 2020 to 31st of March 2021. And then if I could ask you to look at Dr. Braithwaite's evidence in this regard, and you'll find that in Dr. Braithwaite's affidavit, second affidavit, I think, at B419. So the second affidavit on the 7th of December 2020. And at paragraph 19 on page, towards the top of B419. And what he says, it is correct that the council require SHB providers to reapply every year. Those applications are not, of course, mid-year applications. The fact that all providers must reapply each year means that the council can keep providers of SHB services under review. There's 2 points there. The first is that the council didn't, contrary to what Dr. Braithwaite says in paragraph 19 of his affidavit, the council didn't require existing providers to make an application for renewal. But what he does say in paragraph 19 is the point which I've previously been making, is that the reason why that the council rationally should do that is because it allows the council to keep providers of SHB services under review. And
I'm sorry, I'm a little lost. You have to apply for 2020 to 2021 by the 1st of July 2019.
yes, that's right.
Did the incumbent providers actually apply by the 1st of July?
Well, Lord, we don't know whether they applied by the 1st of July 2019. I was going to take you on then to the point in the record where Dr. Soares learns of the fact that existing providers had not had applications assessed, and that comes in. It is found somewhat inconveniently, but it's found in the decision of the trial judge on the interlocutory application, and it's found at which starts at A87, but the relevant page is A94 and A95. And at the bottom of page A94, it starts, Mr. Masters in his submissions invited the court to review the... I'm sorry.
A87 is the start. Which page? A94?
Sorry, my lord. Page A94.
Yes.
And at the bottom of that page, paragraph 24.
Right.
Mr. Masters in his submissions invited the court to review the Conyers letter dated the 4th of February 2021. To Kerry Olson, the letter made statements A, that the BHC is aware of its duty of candor to the court, B, that the court will need to determine whether the unsuccessful mid-year application should have been treated as a full-year application, C, that as the decision under review is the decision to refuse the applicant's mid-year application, disclosure of different applications, namely full-year applications, are unlikely to assist. D, that the BHC had been entirely transparent about the fact that the reasons why applications for new services are being considered carefully during the reform, adding that there was a general moratorium on such applications, as Dr. Soares had pointed out in his first affidavit. E, that approved SHB providers are required to reapply for reapproval each year, but such applications are by definition not for new services, therefore not covered by the moratorium, and are or would be treated differently. And F, that having taken instructions, there are no further documents that could properly assist the court. Stating further, A, the BHC had not dealt with any mid-year SHB applications for new services under the moratorium, other than the applicant's unsuccessful application. B, the BHC had not dealt with any full-year SHB applications for new services since the moratorium, other than the applicant's full-year application, about which no decision had yet been made. That's the second full-year application. But crucially then, C, the BHC had not yet dealt with any renewal application from current SHB providers since the moratorium. This is because repeated extensions have been granted due to the COVID-19 crisis. Now, this is a point which the judge did not accept in terms of the reference to the COVID-19 crisis, because the COVID-19 crisis didn't start until March 2020. But as we know, and as I've submitted, the council ought to have been considering full-year applications from existing providers, which should have been lodged by the 1st of July 2019.
It looks as if they hadn't filed applications because they had received extensions.
Well, my lord, I think the reason why that I submit that's not right, and that's not what Mr. Adamson has said, is that the extensions were not communicated to any of the existing providers until, we may quibble over whether it's October or December, but they were not provided to any existing providers until the autumn of 2020. And therefore, and we also have Dr. Brathwaite saying in his second affidavit that he agrees with our position, which is it is a requirement for existing providers to reapply annually.
This was an application for further discovery, which the judge refused.
Yes, I take you to it only because it's the place. unfortunately, that letter from Conyers is not on the record, and the judgment records the Health Council's position in terms of what had happened to the existing providers.
I'm sorry, I'm now completely lost. There either were or were not applications made prior to or on the 1st of July 2019 by the incumbent providers. Do we know whether there were or whether there were not?
No, we do not know whether there were or whether there were not. The point I make, my lord, is that Dr. Brathwaite says in paragraph 19 of the second affidavit that yes, we always require people to reapply.
I understood that the first time.
Sorry,
hence my question. But Dr. Brathwaite says, yes, we require people to do it each time. Each time is the 1st of July. Hence my question as to whether the incumbent providers had done it by the 1st of July. You say, I don't know whether they did or didn't.
We don't know, and the trial judge didn't know whether they did or didn't. What the reference I've taken you to in the judgment of the first instance judge in terms of the interlocutory application is what the Health Council's attorneys said, and they said that as I sort of just turned away from it.
Well, yes. Well, he said the BHS has not yet dealt with any renewal application from current SSP providers. This is because repeated extensions have been granted due to the crisis. You said it can't be the crisis because that didn't start until March 2020. But when I said, should we infer from that that the extensions were extensions of the time by which you had to make the application, you said, no, you're wrong on that.
No, my lord, there's no indication, and Mr. Robinson didn't say that on Friday when he was asked that question. He said that the extension had been given. He said on Friday in December 2019. He says today October 2019. But either which way, that's after the applications ought to have been in, and the council.
Will you excuse me for a moment? There's somebody at my front door. Sorry, the gas man came to call. I can't really believe we're having this discussion. It must be possible to discover whether any applications were made. Perhaps it doesn't matter. And if they weren't made, what were the extensions of?
Well, Lord, the interlocutory application for discovery, I accept it was unsuccessful. I accept it's not been appealed, but that's what the discovery application was for us to discover inter alia. There were various aspects of it, but neither the trial judge nor Dr. Soares knows whether or not applications were in fact made by incumbent providers by the end.
Can Mr. Adamson tell us? This is ridiculous. Mr. Adamson, do you know whether applications were made?
My lord, I will check. I'm not sure where this takes anyone or anything. I read to you Dr. Brathwaite's third affidavit yesterday, where he at paragraph 18 at B437, where he said the council do not follow or start the usual process for financial year 2020, 2021, and so on, and explains why. It's all set out in sworn evidence. But, and I'm not sure where this takes anyone, but as I say, my instructions are October 2019, the incumbents were told that the SPR process was not going to go through the usual cycle, and their the usual process, that their incumbency, as it were, their approval be simply carried over. That was October 2019. I will seek to find out whether applications were formally filed. Where this takes you, I do not know.
It may not, but I mean, if we're, since we've drawn our attention to this, it may have absolutely no relevance at all. We may well be right, but it seems to me absurd that we shouldn't know what the position is. Right.
I simply, this is simply part of my submission that the existing providers were simply rolled over. We don't know whether or not they were made to apply.
Right. And we've already established this is relevant only if the judge is right that Dr. Soares' application should be looked at in the context of it being a full year application.
Yes, but we've been over. I
think we've been over this.
I don't think I can add to my submissions on that point.
No, I don't think you can.
But I think
Mr. Robinson, could I ask you this, please? Are you making a wider point, which I'm not sure was the subject of your judicial review application, that the appellant has failed in not holding in imposing the moratorium and not holding a review for existing providers? I mean, I'm not quite clear. I'm going back to the point that Justice Bell made a moment ago. Why are we looking at all this stuff unless you're making a wider point here?
Well, perhaps I was wrong to accept the proposition put to me by the Justice of Appeal Bell, but I'm making the point that we've been over this. I'm not going to go back to it again. We've got the position that how Dr. Soares' application was treated as a new applicant. And then we've got the position of how the Health Council were treating incumbent providers.
Yes.
Which we submit, of course, on particular testing is an existing private sector monopoly. And when we say that it was irrational for the Health Council not to treat Dr. Soares' application in the context of what they were doing to existing providers and treat it as a full year application because they'd simply rolled over existing providers with no inquiry. I think I've made that point before. I'm not sure if I've answered your question, my lady, but
I think you have. I'm just trying to understand whether you're making a submission that is not linked to the point that they should have treated this as a full year application. But I think you are linking it to that.
Well, the judge in his decision in terms of rationality, I accept very much focused on this issue of full year, mid-year. But he also, at paragraph 105, if I could just take you to that paragraph in his ruling.
Yes.
And this is where he makes the point about the comparison between incumbent providers and new applicants. He says, paragraph 105 at the bottom of page A52, second, I note that the minister did not reset the SPR and therefore the SAG budget was not rebased. For clarification, I accept Mr. Adams' argument that the fault for that does not lie with the BHC because of those matters fall under the remit of the minister. But obvious consequences flow from such a position, including that life goes on for citizens and applicants. I disagree with the respondents that the application could not have been considered as a full year application for this reason. Again, in my view, the BHC had adopted a rigid and inflexible approach on the type of application when what was really required was for the BHC to adopt the application, to accept the application as a full year application, and these are the important words, and then consider it along with the applications of the incumbent providers and then work through the detailed approval process.
Yeah, I mean, it seems to me that your complaint really is that you had no opportunity to get in on the game, on the full year application, to get in on the process, I should say, not the game, the process of the full year application, given how incumbent providers were being treated.
That's correct, Lydia. We didn't get into the process of the application for the full year because there was no process applied for the full year application to incumbent providers. They were simply rolled over after the date when they ought to have had their applications reviewed. And I don't need to go back over these points, but as I've already submitted this morning, the application guide and the process is not simply looking at the inflow of money, it's looking at quality and other issues, none of which was provided for, none of which was allocated. Now, Mr. Adamson says, and this goes to this point, Mr. Adamson says in his submissions, written submissions and oral submissions, the way in which the council rolled over existing providers was budget neutral. He says that in his skeleton argument. I'll get the paragraph reference for you. He says that was budget neutral by the council. And in my submission, that can't be right because the council has got existing providers providing services. The council doesn't know, for example, whether or not existing providers have used the budget. So I accept there's a finite amount of money coming into the system. But if one thinks about it, think about the existing providers who were providing services in the 2019-2020 year, who we say ought to have had their applications then appraised for the following year. I mean, did those providers actually use the budget? Was the budget exhausted? And so the council is simply rolling them over on this proposition put forward by the council that's budget neutral. But there's no assessment of budget by the council with regard to existing providers or how Dr. Soares might impact that budget, because the council doesn't give any assessment to what happened in the previous year.
You know, the problem with that, Mr. Robinson, is we come back to this mid-year, full-year application so far as Dr. Soares was concerned. I mean, I think with respect, we have heard the argument.
And Mr. Robinson, can I ask you this, please? Is the position that there is still a rollover in relation to the current full year for providers?
As far as we're aware, that existing incumbents are being rolled over, and the council is
again for the year 21-22.
Yes, and is now currently treating Dr. Soares as an incumbent because of the judge's order. But there's been no there's been no assessment of providers since the moratorium was put into place. So just to give you that reference to Mr. Addison's skeleton arguments, paragraph 47, where he makes that point that it's budget neutral.
Right.
I'm not sure, my lords and my lady, whether I can do anything more in terms of the rationality arguments.
No,
I think I need to move on then to the slightly difficult issue of moratorium, which I can deal with quite quickly, I think, because it really, I mean, I fully accept that the judge in paragraph 89 of the ruling is referring to the wrong application, where he refers in paragraph 89 to the 6th of July 2020, which was the decision of the first aborted appeal committee. But the issue of, and I'm not going to go back over any of my previous submissions, but the issue of moratorium, of course, relates to the submissions on rationality, because what the Health Council say in their evidence is that, yes, we provided Dr. Soares with a waiver over the moratorium, but of course the moratorium is still relevant. And that goes to the issue of the rationality arguments, which I've sought to develop this morning. You can't say to somebody, I'm not going to apply the moratorium to you, and then say, well, in fact, the moratorium is relevant. The way in which the council put that, Dr. Braithwaite says in his affidavit, is that, of course, it's still, the reasons for the moratorium are still relevant. Well, that would take me back over my previous submissions in terms of rationality arguments. So I don't intend, unless I can help the court further on the issue of moratorium.
Sorry, can you just, I've got slightly lost. You can't say I'm not going to apply the moratorium to the incumbents and at the same time say.
Well, so my lord, the reference may be helpful to give you the reference. B416 is Dr. Braithwaite's second affidavit, and paragraph 7 is what he says about moratorium. And he says in that paragraph, Dr. Soares criticizes the council of paragraph 41 of his second affidavit for relying on the moratorium, having exempted the applicants from it. This related to the letter from the council dated the 4th of April 2019, which I opened to you this morning. We lifted the moratorium to allow the application to proceed. However, the reason for the moratorium, the reform of the SHB system, remains a factor which the council must take into account. So the judge is dealing with the issue of irrelevant considerations, and I accept that he's referred to the wrong letter. but the council, while the council still say that they have waived the moratorium from Dr. Soares, Dr. Brathwaite says we're still taking the reasons for it into account. And I don't think it would be helpful to go back over my previous submissions. It may test the
Just so I understand it, Mr. Robinson, the judge referred to the second appeal decision letter, and that was in fact the first decision.
He referred to the letter of the 6th of July, which was the decision letter from the first appeal.
Right.
Yeah.
So he shouldn't have been taking that into consideration at all, since it was effectively voided.
Yeah.
Yes, that's right. We would say for different reasons that he was correct to say that that the council was wrong to take into account the moratorium, having said that Dr. Soares was exempted from it. But I think that goes back to my rationality argument, which I've developed. So if it's a convenient moment, I would like to move on to the issue of bias.
Yes.
And I would like to deal firstly with Dr. Brathwaite. I don't intend to get into unless it's helpful to the court, to get into the weeds in terms of the various appeal policies and how the appeal policies refer to who will be in the room. What I would like to do is to take you through the evidence and the documentation in respect of what Dr. Brathwaite in fact did do and what he says about what he did in the process of the initial decision and in the appeals. And in my submission, it is very clear that the judge's conclusion that it can't be, that the judge's conclusion that Dr. Brathwaite's role was not limited to that of a professional and impartial secretary cannot be supported by the evidence. And so if I could
the only evidence I'm right in saying on Dr. Brathwaite's role was his own, and he wasn't cross-examined on his affidavit.
Well, he wasn't cross-examined on his affidavit, but my lord, of course, his third affidavit where he clarifies this for the court. So what happened was that this issue was a very live issue at the hearing in February 2021. And the judge gave the Health Council leave to file a further affidavit. And his further affidavit then elaborated upon this point. And so I fully accept that he was not cross-examined at the hearing. But I just have the caveat to that point that the evidence which the judge partly relied on from Dr. Brathwaite, which we say demonstrates our case on bias, came after the hearing had concluded.
The judge specifically asked for it, did he not?
Yes, that's right, my lord. And he gave us permission then to file responsive submissions, which are in the appeal papers. And if I could ask you, please, on this point, to look first of all at the minutes of the what's come to be known as the technical committee, and those start at C89 of the C bundle.
Yes.
And you'll see that minute is a minute of a meeting on the 5th of, especially the 5th of December, not the 12th of May. It lasted 1 hour, and the attendees are blanked out because the Health Council took the position that they couldn't, in fact, tell us who was on the committee. But if you could just keep your hand.
But they then did. So that
I'll take you to that, my lord. If you could keep your hand at C89 and just look over to C133.
Right. 133.
C133.
Thank you.
You will see a schedule which is attached to a letter from Conyers, and at the top you'll see HTR, which is the technical committee, and SHB, which is the SHB committee. And you'll see that the technical committee refers to Ricky Braithwaite, Bob Kennedy, Cheryl People, David Rogers, Fiona Ross, Keisha Tuckett, Teresa Smith, and Daniel Stovall. And then the SHB committee has Ricky Braithwaite, open brackets, non-voting, and then the further members of the committee. So the Health Council's position and the evidence is that there was no one point they make is that Dr. Brathwaite was a non-voting member of all of these committees, and therefore that is a relevant issue in terms of considering the test in Porter and McGill. But if I could ask you to turn back to C89 and to the minutes of the meeting, you'll see that in each of these paragraphs we have references to the committee. There's no reference anywhere in this document and in these minutes of this meeting to any particular member of the committee making any particular statement. It's a summary document of the Health Technology Review Committee, or the Technology Committee. And I'll come back to this point when I deal with the issue of reasons. But
do we know who drafted the minutes?
We don't know who drafted the minutes. I mean, Dr. Brathwaite cases that he was the secretary. In his skeleton argument, Milady, Mr. Adamson refers repeatedly to Dr. Brathwaite's secretarial role in each committee. But the point I make in respect of that is that his evidence does not refer to himself at all as being the secretary of these committees until one gets to his third affidavit, which he swore after the hearing, in which he refers to his role as the secretariat.
Yes.
He referred, I'll come back to this in due course, but it's Dr. Brathwaite's third affidavit, B43436.
Sorry, could you give me that again? Could you give me that again?
B436.
I hate to interrupt, but my learned friend just said something which isn't quite right. Dr. Brathwaite, in his second affidavit, did explain his role. His first affidavit, forgive me, he says, I attend this meeting, I attend all such meetings. As always, I abstain from voting. My role is to guide the process, help the committees understand the process. I always abstain. That's what he says in his first affidavit, at the very start. It's not entirely fair for my learned friend to say he only says he's a secretary or anything like that in his third affidavit when it's made in his first.
Well, he doesn't use the word secretariat or secretary.
That's fair.
In his first affidavit, does he? I think that's the point that Mr. Robinson was making.
If it's just about but the actual substance is there. But well, yes.
I'll come back to that, my lady and my lords. I intend to take you to the two averments that Dr. Brathwaite made in his affidavits about his role. But the point I was making is that even though my learned friend's submissions very clearly refer throughout to Dr. Brathwaite as purely the secretary, that doesn't appear in his evidence. That word doesn't appear in his evidence at all. The word secretariat appears at paragraph 6 of his third affidavit. He says, it's 4 lines from the end of that paragraph. I am there as part of my secretariat role. But when one looks back at the Health Technology Review Committee minutes, which I was just at C89, Dr. Brathwaite is there as an attendee, and there's no reference, as I previously submitted, to any particular person making any particular point in that affidavit, in that meeting. And I'll just make this point briefly, which is that obviously the content of that Technology Review Committee review is highly damaging to Dr. Soares, in the sense that on page C89, we have business risks, and I'll come back to this in reasons in due course, hopefully briefly. But in business risks, of course, it was noted that the company would likely increase diagnostic imaging testing volumes and thus grow the overall.
So you're on B89? I can't.
Sorry, my lord, I am on C89.
C89. Yes.
At C89 2.1, it was noted that the company would likely increase diagnostic imaging testing volumes and thus grow overall health system cost. Relevant factors included the facility's unfettered ability to self-refer patients, the significant burden on the company requiring high utilization levels to be sustainable, no payment barriers to encourage accountability. I'll leave out the fourth bullet point, paragraph 2.2. The committee cited a number of unavoidable unchecked risks, inappropriate self-referrals, questionable utilization, self-dealing, and that the facility had the strong incentive to participate in unethical clinical practices. So I need not at this stage go through that document any further, but the submission I make is that Dr. Brathwaite is in that committee meeting. He's not listed in the schedule of attendees as a non-voting member of that committee, as he is in respect of the SBR committee, which I'll come on to in a moment. And the very good reason why he's not listed as a non-voting member is because in my submission on the face of that minute, there's no vote. The committee, there is no reference in that minute whatsoever to a vote having taken place of the committee. It's simply a summary minute of a 1-hour meeting by the committee attended by Dr. Brathwaite, in which very damaging and we would say completely unsubstantiated allegations are made in respect of Dr. Soares and his likely business practices from somebody who has an unblemished professional career record. But the key point is that there's no reference to any vote, and he's a member of the committee.
And Dr. Brathwaite's the only person who's common between the two committees. Mr. Rogers may have been, if you allow me a moment, my lord. Yes, you're quite right. Well, if I could take you to the SHB committee. Yes, you're quite right. Sorry, Mr. Rogers comes in later on. He's the only person common to the two committees at that stage. I could ask you then to turn to C99, which is the SHB Review Committee, 19th of December. Again, you'll see at the top, Dr. Brathwaite's name is there because the other committee members were not revealed until the letter from Conyers on the 24th of April. Again, it's a 1-hour meeting. The place in that note for note taker is blank. There's no reference whatsoever in this minute to Dr. Brathwaite being in the room as a secretary. Indeed, it's the contrary to that, of course. It's because of the paragraph 2 of that minute. Committee members were introduced. Dr. Brathwaite, acting CEO of the Bermuda Health Council, and then there's the list of other committee members. And so over the page, if you turn over to C100, where there is a reference to a vote in this document, the committee unanimously voted to reject Hamilton Medical Centre's application to provide services under SHB for the reasons outlined in the findings section. And then beneath that, there are signature lines, but there's no signatures. Laurie Marshall, Chair, Dr. Brathwaite, Acting CEO. So there's a reference to a vote, but there's no reference to how that vote was split. And this is a point which I perhaps ought to have made at the start of this section of my submissions, and that is, which I think probably that the court has, and that is that Dr. Brathwaite is a statutory member of the Health Council. He's not his CEO. This is not a body that has a CEO who is not part of the council. The Health Council Act provides for a CEO. Mr. Adamson took you to those provisions on Friday. It provides for a CEO, and it provides that he's a member of the council. And so he's attending both of these meetings, sorry. And then he provides, of course, as we saw this morning on the 22nd of January, he provides Dr. Soares with the outcome of the deliberations of the council by letter dated the 22nd of January. And that's a letter from Dr. Brathwaite. Sorry, that's not right. That's not right. It's simply signed by the council, and then it's CC'd to Dr. Brathwaite.
So I'll take you back, if I may, to in a moment to the affidavit evidence, but if I could just take you through then the two further minutes of the first appeal, which is aborted, and the second appeal, which is the appeal about which the judicial review was considered. If I could ask you then to turn to page C140, which is the appeal minutes of the aborted appeal. And at C140 at the top, you've got attendees. Again, you've got Dr. Brathwaite as an attendee. You've got Mr. Rogers at this stage, and this goes back to my Lord Justice Bell's point about Mr. Rogers a moment ago. Mr. Rogers is there as the note taker and I take it this was the 18th of May 2020, which was the hearing date. The 5th of June was further deliberations in the next page. Mr. Rogers is there as the note taker. I accept, of course, that in 2.2, this records Dr. Brathwaite having an observatory role. And I accept that on the following page, Dr. Brathwaite is recorded as the note taker. And at 1.5 on page C141, I accept that it records a vote of 3 in favour and 2 for not reversing the decision. And I accept that Dr. Brathwaite is referred to with Mr. Rogers as an observer who was not participating in the vote at that hearing. But the submission I make is that Dr. Brathwaite is part of attends as part of the appeal panel. And the point taken, I think, is that he didn't vote, but he is a member of the Health Council. He's the CEO of the Health Council. He's been at both of the previous decision-making meetings, if you like to put it that way, the Technical Committee and the SHB Committee. And here he is attending the first appeal, which is now accepted to have been a void decision by the Health Council. So then if I could ask you to turn to the minutes of the final, the second appeal committee at C254. And that was the 23rd of December, 2020. And you'll see at the top of 254, the attendees include Dr. Brathwaite, and then open brackets, close brackets, abstained. And again, on page 255, 4.1, the appeal request was for the reversal of the SHB Review Committee. The committee took up the vote, and the initial decision of the SHB Review Committee was upheld by a vote count 0 members in favour of reversing the original decision. 7 members attended the vote, 1 abstained. Just on that abstention point, there's a relevant discussion of abstention. So you may well have seen this in the minutes of the second appeal hearing. But if I could ask you to turn first of all to C157.
C157?
C157, which is the cover page of the transcription of the appeal hearing. And you'll see the appearances are listed there for the Health Council: Stephen Giff, Darian Ray, Iola Oyo, maybe, Michael Redmond, Siobhan Washington-Jones, Dr. Ricky Brathwaite, Shelley Henderson. I accept that this is not the Health Council's doing this, but I wanted to show you that that was the 7 members who were there. And then if you turn over.
So sorry, this is B157.
Sorry, sorry, my lord,
C157. Right.
C157, Lord, has the 7 members of the Health Council who attended the second appeal.
Right.
And then if you could turn over, please, to page C162. And again, if I could look at page C162 at line 17, Dr. Brathwaite says, because there's a debate, the seventh member of the council was late. So when we started the appeal hearing, there was only 6. So there's a debate about quorum. Dr. Brathwaite says, so the quorum is 7, and this 7th person has arrived. There's 7 board members here. There are 6 that will vote, so we can proceed. And then on page 163 at line 8, Dr. Brathwaite again, 7 members are a quorum. There are 7 members here, we can proceed. My submission on that point is that it's perfectly clear from the documentation that Dr. Brathwaite attended as a member of the board, the second appeal. He's counting himself in the quorum. Now, of course, the act which you were taken to by my learned friend, and I'm not sure you need to turn this up, but I'll just give you the reference to the quorum requirements. Quorum requirements are set out in section 6.8 of the Bermuda Health Council Act 2004. 7 members constitute a quorum at any meeting of the council. So rightly or wrongly, it's debatable as to whether quorum is really relevant at that meeting, because of course it's an appeal hearing and so on.
And Dr. Saul's concern was that if Dr. Brathwaite isn't going to vote, there was the possibility of a tie, and he wanted to know what happened.
Yes, I fully accept that. He then said how we're going to do, but also Dr. Brathwaite, clearly the submissions were made by my learned friend, Mr. Masters, at the appeal hearing, that Dr. Brathwaite should not be there at all because he had participated in the previous decisions. It's not so. I do accept that Dr. Soares raises this issue of a tie, but the point I'm making is that it can't possibly be the case that Dr. Brathwaite is simply there as a secretary at the second appeal hearing, whenever he's a statutory member of the council, and he abstains from voting. A secretary who's there as somebody who's simply there to assist, to take a note, and to answer questions about procedure, doesn't get to abstain from voting because they wouldn't have a vote.
Where is the request by Mr. Masters that Dr. Brathwaite should absent himself?
I may need a moment, my lord, to find that. Find that for you.
Well, then, just any time, no doubt.
Yeah,
Mr. Masters can find it while you're speaking.
Yeah. So if you turn to page C170, and there is a section of submissions here, but the section that I have highlighted starts at line 16. So when you consider these factors, there's a real question as to whether or not Dr. Brathwaite could possibly be a person while sitting on the panel who could be expected to operate in whatever function he's operating in impartially. That's Dr. Brathwaite. I should also mention that Dr. Soares' affidavit evidence clearly establishes that the issue of Dr. Brathwaite's partiality was raised also at the first appeal hearing, in which the suggestion that if it were made that the issue of partiality wasn't raised, it's in the correspondence pre-first hearing with regard to Dr. Brathwaite. It was raised at the first appeal hearing, and it's dealt with in Dr. Soares' affidavit. Which one? Sorry, at page B25, which is Dr. Soares' first affidavit. Sorry, that's the wrong reference.
What are we looking for? Dr.
Yes.
Soares' second affidavit?
Right. Sorry, it's Dr. Soares' first affidavit. It's page B25, and there's a subheading towards the top, SHB appeal hearing.
Right.
The paragraph 39. describes how the hearing was conducted. You'll see at 39, the request is made to record the hearing. Dr. Miller expressly objected to this. As a result, the council refused to record the hearing. Paragraph 40, at the hearing, in addition to raising each of the arguments detailed in the grounds of appeal, the appellant's attorneys requested that any member of the appeals panel could also be involved in the SHB decision, including but not limited to Dr. Brathwaite, should recuse themselves from the hearing of the SHB appeal in accordance with section 9.3 of the appeal policy. The application was made at the beginning of the hearing and clarified and repeated at the end of the hearing. And that did not happen. And you'll see in paragraph 41, Dr. Brathwaite was a member of the HTR committee, refused himself and relied upon the fact that he was a non-voting member of the appeals panel. So again, he doesn't say in paragraph 41, Dr. Soares' account in paragraph 41, which hasn't been challenged, doesn't record Dr. Brathwaite as saying that he was there simply to be a secretary of the appeals panel. He was there as a non-voting member of the appeals panel. And if I could please then go on to just to show you what Dr. Brathwaite said about, this is the point Mr. Adamson is anxious that I draw to your attention, what Dr. Brathwaite actually says about what he did. That is that's a B150 in his first affidavit at paragraph 28.
I'm sorry, Mr. Robinson, I was looking at something else. There's references.
It's B151, paragraph 38. Sorry, 28. So sorry, B150, paragraph 28.
I thought you said 151. Is it?
Yes, sorry, I was reading for the wrong paragraph. B150, paragraph 28.
Right.
If you have that, it reads, the application went through the usual process of technical review. Technical committee for the application consisted of, then he lists the names, and interestingly or noteworthily, he says, and myself at the end of that sentence. Myself and Cheryl aside, these individuals are not members of the council, but external experts who understand the industry. The minutes of the technical committee meetings are exhibited. I attended this meeting as I attend all such meetings. However, as always, I abstained from voting. My role, as I see it, is to guide the process and help the committee understand the process and what has gone on before. I always abstain from the decision. Now, I make the point that that averment I submit in itself should satisfy the test as to concern of apparent bias, because there's no evidence in this case on behalf of the Health Council from anybody else who was at any of these hearings. The only evidence is on behalf of Dr. Brathwaite, on giving evidence on behalf of the Health Council. And he, in his averment in his first affidavit, I accept that he says he abstained from voting, but we don't know, because nobody's given an account of what he means by help the committee understand the process and what has gone before. And so even at that averment, and I'll come on to his second averment, which I say makes exactly the same, rings the same alarm bells, is that averment would give a reasonable, a well-informed, reasonable person a concern that what Dr. Brathwaite is doing at the technical committee is not simply acting as a secretary taking a note, but rather that he's engaged in the debate on the committee.
So you say that passage in Dr. Brathwaite's affidavit is fatal from the bias point of view?
I do say it's fatal from the bias point of view, but of course he elaborated on that at the invitation of the judge, because this issue was raised in the course of the judicial review hearing. And if I could ask you please to turn over to his third affidavit, which is at B435.
Right.
And you'll see at paragraph 3A, he swore the affidavit to confirm on oath the statements made in court as to my involvement in the various meetings. And over the page, at paragraph 436, paragraph 5 and 6, I confirm that my role is as explained by my attorneys to the court. I do not take part in decision making or discussions about the decision. Now, sorry, I'll just read paragraph 6. I start each meeting of this type, and I include here all the meetings where the plaintiff's application was considered, by explaining to the other the other members, the purpose of the meeting, what the documents are, and what the process is per the documents they would have received. This is important as not all members have the same level of knowledge about the legislative mandate of the Health Council. I also explain my role, that I'm not there to make the decision or to take part in the discussion. I'm there as part of my secretariat role. That's the only reference to the secretariat role. And this is, again, I say this is a crucial sentence and a fatal sentence. I do answer questions as they arise, for example, about process, technical issues, or context for what the documents are. I do not seek to influence the discussions, nor is there any reason why I should want to. This is my practice in all such meetings, including the ones relevant to these proceedings. So I respectfully say what Dr. Brathwaite was seeking to do is completely irrelevant. But what he says he does is that he answers questions about process, technical issues, or context, and he gives those as an example of the questions that he answers from the panel. And there's no evidence before the trial judge. There's no evidence of what questions he was asked or what questions he answered. Quite open to the point is taken against me. My Lord Justice Bell, of course, mentioned this already in terms of there's no application to cross-examine Dr. Brathwaite. But I say that there's no evidence of any other member of the decision-making committee. The only evidence is from Dr. Brathwaite, who Dr. Brathwaite would have us, the court, believe, and he was there simply as a secretary.
You say, Mr. Robinson, there's no need to cross-examine him because the body of his affidavit gives you what you need.
Yes, my Lord, and that was the position we took at first instance, is the position we still take, which is that we don't need to cross-examine him because his own. If you read the contextual documents which I've taken you to, and they show who was in the room, what capacity they were in the room, and the court had the benefit of the transcript of the second appeal hearing, where Dr. Brathwaite is clearly there as part of the quorum. We didn't need to cross-examine him because his own account of his conduct is that he's there as a board member, and he's there to answer questions, for example, about process, context, and the documents. In his first affidavit, as I've opened to you already, he mentioned that he gave the technical committee context of, quote, what had gone before, unquote. Well, what does that mean, and how does that look from the position of a well-informed person in this process? We say very clearly that gives that person a very serious cause for concern that Dr. Brathwaite is influencing. Whether he of course he says I don't do it, that's subjective.
But why does Dr. Brathwaite answering context and technical questions and so on equate to his having an interest in the outcome?
He doesn't have, my Lord, he doesn't have to have an interest in the outcome. And so, my suggestion, that's not the test.
And you're not suggesting that he does?
He's the CEO of the Health Council, and he's also.
But are you suggesting that he has an interest in the outcome?
Well, I'm not suggesting he's got a personal interest in the outcome. I'm suggesting that he is a board member, and that he, even on his own account of his participation in the initial decision making, was a participant. And I've taken you briefly to the minutes of the technical committee and the extremely damaging, and we would submit clearly untrue and perhaps go further and say outrageous comments about Dr. Soares and suggestions about business practices, and not a shred of evidence about that. Completely untrue. And here we have the same person who's in the committee meeting, considering that technical committee, sitting as a member of the panel, of the appeal panel. And I say it doesn't matter that he abstained. or that he thought he wasn't influencing the outcome. The council hasn't put forward any. And I'll come to this in due course, but in the case law that Mr. Adamson looked at, there was evidence from other members of the panels that the person who was being complained about, in fact, did not do anything to influence the outcome of the decision. But in this case, the trial judge in the Court of Appeal, in my respectful submission, has no evidence from anybody else as to whether or not the appeal panel members were influenced by what Dr. Brathwaite said in terms of answering questions which are not detailed in the evidence as to process technical issues or context.
So are you saying, Mr. Robinson, that we can draw an adverse inference against the council because of the absence of any evidence from other people?
I am saying that, and I think we said that in our skeleton.
Yes, I think you did.
It was open to the trial judge to draw the inference and sorry, I'll just turn to that. Paragraphs 23 and 24. So 23 and 24 of the skeleton argument as an alternative argument submitted that.
Sorry, where are you now, Mr. Robinson?
If you have my skeleton argument at paragraph 23 on page 5.
Right.
My lord, just because of timing, can I just raise 2 points so my learned friend can deal with them and hopefully save on reply? First of all, it's not clear to me at all from the judgment that the learned judge did draw such an inference. As my learned friend is saying he did, he's inviting you to do so, but the learned judge didn't. If you want to read the actual judgment, but no doubt my learned friend can take you to why he says an inference was actually drawn when the analysis is on the basis that I say the opposite. And secondly, my learned friend said that the case, which is his own case of Ward, he just characterized it on the basis that evidence was put forward by other committee members to establish that Mr. Naismith did not say anything unusual. Well, no, that's, again, he needs to get to his own case. That's not what his case says. Mr. Naismith did intrude into the discussions. He was adamant that he was making submissions. He drew the attention of the committee to circumstances which made the case serious.
Lord, that's just simply not right. Lord,
it's at page 5 of Ward and Bratt, the last paragraph on the page. But no, that my learned friend can take you to it.
I'll take you first of all, if I may, to the judge's reasoning, which is at paragraph 79 to 83, which is A44 to A46.
Paragraph 79 to
79 through 83. And it's quite detailed reasoning.
Yes.
He starts at paragraph 79 and he deals with the proposal guide and the places where the Dr. Brathwaite is referred to as secretary. And his conclusion is 4 lines up from the end of that paragraph. In my view, only the appeals policy expressly defined that the CEO is the secretary of the appeals panel. Per the SHB proposal guide for the other committees, the secretary could have been somebody else. That was answering the point that the guide provides for him to be secretary, therefore he should be there as secretary. Second, in paragraph 80, his third affidavit, 2nd of March, this is of course after the hearing of the judicial review. And then he summarizes in A, B, C, D, E, and F points, which I've effectively opened to you in terms of reading out his affidavit. And he says then, and this answers Mr. Adamson's criticism of my submissions in the top of page A45. It appears that Dr. Brathwaite was involved in every step of the application process for the applicant's application. These stated rules gave me cause for concern, particularly in light of some of the minutes which do not state that he did not participate in discussions and did not vote. Now, I don't say he says there in so many words, I'm drawing an inference from those minutes, but that's clearly in my submission what the judge is doing. And then paragraph 81, in respect of
my lord, I'm sorry, but that's not sufficient. My learned friend said in his submission to you that the learned judge drew an inference and found that Dr. Brathwaite was not telling the truth. Now, and that he did take part. He did, and that's not what the learned judge finds. He just said he notes concern. He didn't make any finding or draw any inference at all. And indeed, when you read the rest all the way down, he's dealing with on the basis that Dr. Brathwaite was there as a secretary, and he deals with the fact that, in his view, well, you should have a different secretaries for every meeting. So it's not right that to say that the learned judge drew an inference and that you should uphold that inference. It's not correct.
I said it is right. If I could perhaps complete my submissions with all due respect to my own friend, my lord and my lady, if I could keep on going through his judgment at paragraph 81. There he deals with the technical committee, the SHB committee. And then 4 or 5 lines down, Dr. Brathwaite was taking with him the knowledge of all that had gone before him, including discussions. It seems commonsensical to me that if the first appeals panel or the second appeals panel needed secretariat, then despite despite the guidance, i.e. the SHB guide, someone other than Dr. Brathwaite should have been assigned to that role precisely because of his prior involvement in the other committees. The judge is clearly is of the view that as he says himself, he's giving the committees information about what went before. Then he continues, alternatively, if the BHC recognised that in any application there could be an appeal and the SHB proposal guide expressly stated that the CEO was the secretary, then in all of the earlier meetings, the secretariat should have been someone else from the BHC staff as envisaged by the SHB's proposal guide. And then this is finding, in my view, using the same person as the secretariat for all 3 stages of the application process. And then for the appeals process would cause a reasonable and fair-minded person sitting in the second appeals panel, knowing all of the relevant facts, to have a reasonable suspicion that a fair hearing is not possible. Surely the expectation would be that an independent panel would be assisted by a secretariat that had no involvement in the previous stages. And then he applies the ex parte Thompson test.
That's where I have a problem, because he's not actually applying the test of Leicestershire Fire Authority ex parte Thompson, because the chief fire officer in that case was the person who had made a complaint in relation to the subject officer, and therefore it could reasonably infer that he did have an interest in the outcome.
Well, if you read, my lord, to the end of that paragraph, when he refers to ex parte Thompson, he says that he relies on that case for the general rule of great importance, that not only must justice be done, but it must be manifestly seen to have been done. I accept that ex parte Thompson is a different case, because the chief fire officer was someone who objectively you could say was a biased non-voter, and I accept that there's an error in our skeleton argument in that paragraph which refers to that. But the general proposition that the judge relies on the case for is the general proposition that justice must be done, justice must be done, but also must manifestly be seen to be done. Now, I've taken you to this morning.
But the problem with it being seen to be done was the presence of the chief fire officer who was coming from a position.
Yes, but Lord, that's correct. And but what I've taken you to this morning also are the minutes of the technical committee, and the minutes of the technical committee in which Dr. Brathwaite is not isolated as a non-voting member or as a note taker, include very damaging suggestions about Dr. Soares.
Could you just give me? You referred to that. Could you just give me that reference?
Yes, my lord. So it's the technical committee minutes are C89 through to C92, and the particular and paragraphs 2.1 and 2.2.
Just wait till I get there, if you wouldn't mind. So C89.
C89,
2.1,
1 and 2.2 were the paragraphs that I previously referred to.
But there's no reference to Dr. Brathwaite having said anything here.
No, but there's no reference, my lord, to anybody saying anything in those minutes. The only reference is to the committee. And as I pointed out,
that might be an area where cross-examination could elicit who said what. But you can't say that this is Dr. Brathwaite's view, can you?
No, but I can say it's the view of the committee of which Dr. Brathwaite was a constituent member. He's not recorded as the secretary. He doesn't even record himself as non-voting in Conyers' schedule of who attended the meeting.
Right.
So what was the injustice that a reasonable observer would think might have been done?
Well, my lord, the reasonable observer would, Dr. Brathwaite was on the technical committee, which included these suggested expert views about Dr. Soares' application. He was then on the decision-making committee, which refused the application. He was then on the first appeal, in which there was an express application that he recused himself. He sat as a member of the first appeal, which of course was aborted because there were two other members on the appeal who also sat on the SHB committee. And then he finally sat on the final appeal. My submission is that a reasonable observer, observing this from a position of information and knowledge, would clearly conclude that someone who had sat on the first, especially the technical committee, and had sat on the first appeal, would have a reasonable suspicion that Dr. Brathwaite could not bring to bear an independent mind to the final committee. And the suggestion, and I've dealt with this point already, the suggestion that he was not involved in the discussions which led to the final decision can't be sustained in my submission, because on his own evidence, he's answering questions. He gives examples of the questions that he answered, doesn't give all of them, and there's no evidence from anybody who was actually on the committee.
So what I think you say is that either you say the judge made an inference, or in any event, on the material that we have, the fair-minded observer would, in the absence of further explanation, have thought that there was a real possibility that Dr. Soares was prejudiced because because Dr. Brathwaite was not bringing a wholly independent mind to the process, of which he was a part, even if not a voter.
Well, I think, Lord, that's the conclusion the judge reaches at paragraph 83 at the very end of his conclusions, where he refers to that's page 46. Sorry, Lord.
Yes.
And he refers to Ward and Bradford Corporation in respect of exceptional circumstances. And he says, however, I find it difficult to reconcile all the knowledge that Dr. Brathwaite possessed from the previous hearings and providing information to the committee with his statement that he was not involved in the discussions. In my view, I do not accept not being involved in the discussions and not voting as an exceptional circumstance for why the rule should not be applied in its full rigor in this case. I also do not see any other exceptional circumstances.
Well, that's slightly curious.
Slightly different point.
Assume that you have somebody who attends all the meetings and is silent throughout. He says, I didn't vote and I wasn't involved in the discussions. It'd be difficult to say in those circumstances, not involved in the discussions, I did not take part. Might be difficult to say in those circumstances that there was reasonable grounds for thinking that some injustice had been done, wouldn't it?
But there's no evidence, my Lord, from any of the other committee members. And I accept your proposition, but in the case law which has been referred to, which I can take you to, in each of those cases, the relevant cases which were discussed on Friday, there was evidence from members of the panel who aver that there was no influence. Of course, this case is the opposite of that. We've no evidence from anybody on any of the panels, save for Dr. Brathwaite, and his own evidence in these proceedings gives evidence of what he perceives to be the reason why self-referral is of concern in the context of this application, i.e. the very points that the technical committee, which I've taken the court to, the very points that the technical committee mentioned in terms of self-referral unethical practices, then are the very things that Dr. Brathwaite, in his evidence before the first instance court, gives evidence about. But yet we're asked to accept that Dr. Brathwaite had no influence on the committee, even though he's the very person that the Health Council put forward to the court, saying, first of all, I say I had no influence, but second of all, the reasons why the technology committee came to its view are justifiable reasons.
Right.
Is your submission, Mr. Robinson, that basically you can't have somebody sitting on an appeal from himself, even though it wasn't clear what role he was playing either at the first instance level or the appellate level?
Lydia, it does come down to that. I say he was a constituent member of the original decision maker,
Yeah.
and he was a constituent member of both appeals. And you can't have him being, you can't accept him as being somebody who an observer would accept could treat that second appeal on a fair basis, given his involvement in the original decision. And we've got this extra element of the first appeal, of course, which clouds the issue because
Yes, I see that. I see
nobody
that.
accepts it was wrong.
We'd all like to sit on decisions in appeal from ourselves.
Mm.
So, my lords and my lady, I think that takes me through my submissions on Dr. Brathwaite, unless I can assist further on that point.
Well, yes, you can. Just forgive me a moment. Well, are you coming on to the question as to whether or not the judge could make his own decision?
Yes, but what I've got left is Dr. Richmond, the reasons challenge.
Oh, right. Okay. Well, don't let me take you out of order.
And his own decision.
Okay. Why don't we deal with Dr. Richmond and then have a break?
Dr. Richmond, I can deal with hopefully fairly briefly. This is a paragraph 77 and 78 of the judge's finding. Sorry, that's a page A43 and A44.
Yes.
And I accept that the judge has made a finding of actual bias against Dr. Richmond on the basis of Davidson and Scottish Minister's case. I mean, that submission, that was not the way in which we put the case to the judge. We didn't put the case to the judge that he was guilty of actual bias. The case which we put to the judge and we say still supports a finding of apparent bias is...
So do you say that the judge was wrong to find actual bias against Dr. Richmond?
In my submission, the judge, he refers to Davidson and Scottish Ministers, and perhaps if we could just turn to that case, I can deal with this point very quickly. It's at tab 3 of the authorities bundle, and it's paragraph 6 of that decision. And if you have that authority at the third line of paragraph 6, which starts thus a judge.
Thus a judge, right?
Thus a judge will be disqualified from hearing a case, whether sitting alone or a member of a multiple tribunal, if he or she had a personal interest which is not negligible in the outcome, or is a friend or a relation of a party or a witness, or is disabled by personal experience from bringing an objective judgment to bear on the case in question. Where a feature of this kind is present, the case is usually categorized as one of actual bias, but the expression is not a happy one, since bias suggests malignity or over partiality, which is rarely present. What disqualifies the judge is the presence of some factor which could prevent the bringing of an objective judgment to bear, which could distort the judge's judgment. So that's the section of that case in which the judge was relying on in a finding of actual bias. That it's not a personal financial interest, but that Dr. Richmond had a personal interest because he was CEO of the hospital. Now I accept that I accept that the case we put before the judge is one on the basis of apparent bias, and I really seek to uphold that finding. I don't. I accept that it's while I say the case does extend to personal circumstances beyond financial interest, which is what the judge obviously was considering in paragraph 77. I would prefer to put my case on the basis of apparent bias. And so he then says, 4 lines up from the bottom of paragraph 77, can it be said that Dr. Richmond, in his participation as an appeal panel member, would meet such a criteria, which is the criteria in Scottish ministers? To my mind, the role of Dr. Richmond as the CEO of the hospital could prevent him from bringing an objective judgment to bear, which could distort his judgment. And then over the page, also in respect of Dr. Richmond and apparent bias, I again rely on the line of cases starting with Porter and McGill. I am 3 lines down. I am of the view that the fair-minded and informed observer would conclude that there was a real possibility of bias on the part of Dr. Richmond once all of the facts of the circumstances are considered, including his role as CEO of the hospital and to the significance of the SHB to the hospital.
But Mr. Robinson, going back, I mean, the judge specifically said that on the case of Davidson and Scottish ministers, the role of Dr. Richmond could prevent him bringing an objective judgment to bear, which could distort his judgment. I quite understand that you don't want to be critical of the judge in relation to his finding of actual bias. I still don't have a very good understanding as to how he reaches this conclusion.
Well, I accept, Lord, that it's very difficult to draw a clear distinction between on the judge's reasoning between his finding of actual bias and his finding of apparent bias.
Right.
Because he appears.
You want to rely on the latter, and I understand that.
Well, I prefer to rely on the latter because I don't need to rely on the former in my submission, and I didn't put my case in that way. And
you don't want to now. And
I don't think it's necessary or
no.
Nor am I prepared to say that the judge was wrong.
Well, if you never put it on that basis, it wasn't open, was it, to the judge to find actual bias?
We didn't put our case on that basis. We put our case on the basis of apparent bias.
Yes.
And so I think it's a debate perhaps which I ought not to continue because we didn't put our case on that basis. And we were happy to put our case on appeal on the basis of apparent bias.
Okay.
Which we obviously stand over because, and this, in the interest of time and also the patience of the tribunal, I'm not going to go back to the issue of the SHB and the SPR setting, but I'll just try and do it in a very brief proposition, and that is that the point taken against us with regard to Dr. Richmond is that he's the CEO of the hospital, and therefore he's a fair-minded observer would not consider that he would not be able to make an impartial decision. But of course, the funding for the hospital comes from the SPR, and the hospital is doing outpatient testing, and Dr. Soares wishes to do outpatient testing under the SHB policy. And the proposition from Learned Friends seems to be that because the hospital is now getting a block grant, that therefore Dr. Richmond, no impartial observer could consider that would be a problem. Of course, the hospital is getting a block grant this year, but if Dr. Soares' application was successful and testing goes to his clinic, well, when the hospital is being reassessed for its block grant in future years, well, of course, that's going to be a relevant issue as to whether or not the hospital gets the funding year on year. And so I simply said it was the judge's conclusion that Dr. Richmond, because he was the CEO of the hospital, and it's putting it too crudely to say the hospital is a competitor because it's much more complicated than that, because the hospital is getting its funding in a different, part of the same SPR, but in a different way.
But why should Dr. Richmond be concerned if the block grant is reduced to reflect the fact that the hospital is performing fewer CAT scans or MRIs, because that will be the case that it will need less money?
Yes, but I mean, I respectfully said that Dr. Richmond, as the CEO of the hospital, is obviously concerned to maintain his own institution in terms of testing numbers, because firstly, it keeps him getting his block grant. Secondly, it keeps his staff employed. I mean, he made this point in the appeal minutes, and he makes the point about he is the only person. Well, this may not be correct, but I certainly recall him asking me questions about fragmentation, and that's found in the second appeal minutes at C223 and C226. and at 223, if you have it.
223.
C223.
Where Dr. Richmond's asking questions about fragmentation.
That's exactly, my lord. I don't need to take you through that in any detail, but he's asking me questions and putting to me that there's a problem with fragmentation of the hospital, if testing is done outside the hospital, and fragmentation in the sense of staff in the hospital not having enough testing to keep up with their skill set, to put it very, very broadly. And so there, even in that the transcript of the second appeal with Dr. Richmond, he's asking questions about effectively maintaining his own business, and of course the hospital is competing with SHB providers for outpatient testing, and I say that satisfies the Porter and McGill test, because and I don't need to get in, I hope, to the mechanics of how the block grant is set. The point is taken that because there's a block grant, therefore the hospital shouldn't be interested. Well, block grants can go up as well as down as well as up. And I simply submit that Dr. Richmond, the impassioned but well-informed observer about the medical funding system in Bermuda, would be concerned with regard to Dr. Richmond's presence on the appeal panel. And again, of course, we took this point and we were, it was rejected. This is not the sort of suggestion, there can't be any suggestion in this case that points of bias are taken, that we let the council do these things and then we take points of bias. All of the points of bias that we take in this case were taken when they should have been taken at the hearing.
I wonder if my learned friend could take your lordships and your ladyship to C225. I took you to it on Friday, but it's where Dr. Soares says there's no issue of fragmentation in relation to the hospital. C225, he disavows the very argument my learned friend just made. C225, line 21 down. Could I add something, guys? Fragmentation, he goes on, there's no threat to the hospital.
There's no threat. Well, I don't accept that intervention is a valid intervention. Dr. Soares, yes, fragmentation is a reality. However, the letter back in July 2019, this is the letter which is in our appeal papers, in which we refer to this in our appeal papers in February 2020 as the new information, where the hospital issues a press statement, issues a policy saying that they were going to have to rely on the private sector.
There's a difference, isn't there, Mr. Robinson, between Dr. Soares saying as part of his application there isn't a risk of fragmentation, but Dr. Richmond, as it were, protecting the hospital's business, being concerned there might be an issue of fragmentation. So it depends who's looking at the question. Dr. Soares is bound to say, no, in support of my application, there isn't a risk of fragmentation. But that doesn't mean that Dr. Richmond might not be concerned that indeed there would be fragmentation.
But he actually agreed with Dr. Soares at line 7 of 226.
But my lord, if you read, and I'm sure you have, lines 1 through 6, Dr. Soares says, I don't think there's any threat that the hospital would have so few that it couldn't maintain a throughput, because the hospital itself has chosen, he said, it actually has too much, and it must share on the private community.
And Dr. Richmond agrees with that.
Yes, but Dr. Richmond is asking me questions about his concerns about fragmentation.
All right.
Well, they seem, Dr. Soares and Dr. Richmond seem to be agreed that whatever else fragmentation does, it's not going to affect the hospital prejudicially. Okay, well, there we are.
Well, I think, Lord, in answer to that, if I just very quickly answer that point in C223, where Dr. Richmond starts to answer those questions, he says at lines 20 to 22, if the hospital was to have very little exposure to a modality, for instance, CT, I'm using this only as an example, and then at 24, the only time that it was challenged would be once a year when the only place could be done in the hospital, when the only places could be done in the hospital, are you accepting that the hospital service must maintain a certain modalities to maintain currency? I'm asking you if this isn't something that you accept. And then I think the next comment is actually a misprint. I think that was me replying, not Dr. Richmond. That's why I accept it's an issue for the hospital. But I think the broader point, I think, is that it's really simplistic to say that the hospital doesn't have an interest in a new provider of SHB imaging services, given it's a provider of outpatient imaging services.
Right. Well, that's probably a convenient moment to adjourn. How are we getting on for time?
I think I probably need about another 30 minutes.
Okay. Well, shall we take a 45-minute break? Come back at what would be a 4:45 our time, 1:45 yours, I think.
Yes.
Okay.
Could I please just mention, I'm sorry to mention this, but as I said on Friday, I have a hearing at 2:30 in front of Mr. Justice Norton. So it'd be very helpful if I could have an indication as to whether we're going to, if necessary, continue beyond 2:30 so that I can update the court.
Yes, we're going to continue until we finish.
Very well. Thank you, Lord.
Thank you. Right, I think we're all, oh, yes, we are all assembled. Yes, Mr. Robinson.
Thank you, my lord, my lords and lady. I think I'll move on to the reasons challenge, if that's acceptable.
Yes.
And the judge's finding in respect to the reasons challenge is at A39 to A40. I'll not, don't plan to open any of those paragraphs to what I simply say is that the judge find that appropriate reasons were not given in light of the circumstances. He refers back to the range of arguments which were before the appeals panel. They're found on page A37 at paragraph 6.
So which passage of his judgment are we looking at?
So the reasons decision is from paragraph 69 through to 72 on page A39 to A40.
Yes.
And he says he disagrees. He finds that the adequate reasons were not provided. He says in paragraph 71 on page A40, third, I am of the view that the principal important controversial issues were the issues identified by the applicants as arguments. And I was giving you the cross-reference to that paragraph in his judgment, which was paragraph 63 on page A37, in which he listed the principal what he considered were the principal important controversial issues. And he lists them from 1 through to 6: the full year argument, the mid-year argument, the jurisdiction argument, the fitness argument, fairness argument, the monopoly argument, and the HTRC argument. And he accepts that he accepted our argument that the minutes of the second appeal committee, which are found in the C bundle at C254 to C255, didn't satisfy the test for reasons. It clearly on page 259 at box 2, the appeals panel is considering the full year argument. It's headed at 2.1 mid-year against full year, and then at 3.1.
Sorry, a little. Where are we?
I'm sorry, Lord. B259 is the minute.
B259.
259, yes.
Sorry, is it in the C bundle or not?
I'm so sorry. I'm reading from the wrong page. C254 is in the C bundle at the bottom of the page. I'm sorry, Lord. My eye went to the top of the page.
No, don't worry.
Right.
So C254, and if you just turn back one page, C253, you'll see the cover letter from Dr. Brathwaite. The Health Council regrets to inform you that services have been denied. The record of the appeal meeting can be found below. And then in the third paragraph, please note that there's no reapplication restrictions. And over the page then at C254, we effectively have two boxes which deal with reasons, which is the box which is about mid-year against full year on the left-hand side of the topic. And then paragraph 3 is the issue about statutory construction, which went against us alone, which was not pursued on appeal. So effectively, what I'm showing you is that the only articulation of reasons by the second appeal panel was in respect of the full year, the argument which we advanced that the Health Council ought to have considered the application on the basis of the full year criteria. But as I've pointed out to you in paragraph 63 of the judgment, the judge lists the other reasons which were put forward with respect to the argument that the appeal ought to have been allowed.
Yes.
And so the judge effectively held that the principal important controversial issues had not been dealt with in the reasons, and that the applicants therefore, in his quotation.
Just, I mean, we're going back to 63. The judge sets out six arguments, of which the tribunal dealt with the mid-year argument and the jurisdiction argument doesn't arise. Are these taken from some skeleton or?
Yes, they are. So, so the tribunal dealt with 1, 2, and 3 because they dealt with the full year and the mid-year, because that's the same argument. And
yes, it is. Yeah.
An argument. So that's the fairness argument, the monopoly argument, and the HT or C argument, and that's taken from the skeleton argument, which is before the trial judge, which is in the B bundle. At B, the reference to it it starts at B445. And B463 is the reference in paragraph 76.
Well, just a minute. So they dealt with the full year argument and and the mid argument. The jurisdiction argument doesn't arise. So it's the last three that you say were not dealt with.
Yes. The fairness argument, the monopoly argument, and the HT or C argument. And then if you look over the page.
Just a minute, just before we go cantering on, I'd just like to see B, you say we should look at B445.
Sorry, B463.
463, okay. Right. Okay. All right, so we'll find them all there.
So 463 lists the 6 arguments, and then over on 464 and following, I'll just give you the references to where the fairness argument starts at paragraph B1, page 465.
Right.
Mr. Robinson, isn't the right place to be looking for these reasons, not in the submissions that you made to the judge, but in the submissions that you made to the appeal committee? Because that's what's being said, is that the committee didn't deal with or didn't give reasons for its decision. So don't we have to look at the transcript to find out how you did put it to the appeal committee?
Yes, Nor, I accept that, and I also accept that the transcript reveals that the, and I also accept there's an overlap between what the judge and what we call the fairness argument and the monopoly argument, because of course that goes to the same issue of full year. I accept that there's a duplication there between the full year argument and the mid-year argument. And I accept that we need to look at the transcript. But what I say about the transcript is that it's quite clear from the transcript that effectively we ran out of time because the council starts at 2:30 by saying, or the appeals panel starts at 2:30 by saying we've got a hard stop at 4 o'clock.
Yes.
And so when we get through, and if I could ask you to turn to C222. C222.
222.
222, yeah.
Yes.
You'll see at line 13, if you have that.
Yes.
And you'll see that I submitted them to the appeal tribunal, and the final point is that the appeal papers, you'll see that we refer to the HT or C reasons. These are the technology committee reasons. Now, then I say now even the last panel does not seem to pay attention to the HT or C reasons, and I respectfully say that that's exactly what you should do, because the HT or C reasons, which are the Health Technology Review Committee reasons, are full of points which are not fit to be considered by a public body when you're making a decision. And then I continue just on the top of page 223 with same reference, third line. I asked you to completely clear out of your mind the HT or C report because it's full of old allegations without any support in the evidence and full of hypothetical risk, which no part of a proper decision-making by this body. And then Dr. Richmond, and I say, I appreciate that I've gone very quickly. And then Dr. Richmond asks me about fragmentation. And we've been over that this morning in the following two or 3 pages with Dr. Soares intervenes. And then if I could ask you to turn to C227. And I said at line 6, well, I've come really to the end of my submissions. The only thing that I would say is I've come rather more quickly than I would have liked to have done. I appreciate, I don't know what I must say, I said I appreciate that you were busy. I would just urge the members of the panel to carefully review our written submissions, appeal papers, that we also carefully prepared, because some of the issues which I have gone over very quickly in respect of the fragmentation reasons and the HTRC reasons were very carefully and detailed provided for in those written submissions. And then I go on and I say I turn it around the other way. If you've got further questions, you should ask us any further questions. And it's clear by this stage that members of the panel are saying that they're leaving because the time is up. I don't say anything about that. That's just how it happened. But I don't accept the point that that the judge was wrong to say that the principal important controversial issues were not before the appeals panel and were not.
But where are the submissions to which you were referring that were before the appeals panel?
Well, they're in the original February.
I'm sure they are, but where are they in the paper?
Sorry, my lord, if you give me a moment, I'll turn to them.
C108. C108.
Yes, thanks to Mr. Adams, C108. And so you'll see, my lord, if you could turn to C114, C115, and C116. I appreciate that they're called somewhat different names than appear in the transcript and then in the judgment. But you'll see the evidence reasons. I accept that this overlaps with the full year, mid-year argument. Of course I do. You'll see the evidence reasons at paragraph above 28 on C114, fragmentation reasons.
Just a moment.
Sorry.
On 114.
C114.
Yes, evidence reasons, right.
Because the previous page was grounds of appeal jurisdiction, and that in the previous page, C113, is the paragraph 25 that I drew your attention to this morning, which is where we make in those submissions the full year argument. And then C114, evidence reasons. And we refer to the new information of the hospital not having sufficient capacity. On C115, you'll see a heading fragmentation reasons, paragraph 32 and 33. And this is the issue about the dilution of service provision because not too many machines, not enough technicians, effectively, to put it crudely. And then there's grounds of appeal 34, 36, 37 over the page. And then in my submission, paragraphs, page C116 and C117 are important and crucial for this part of our argument on this appeal. Is that we set out there on page C116, the paragraph 38, reference to the HTRC report, and 3 subheadings, unnecessary treatment allegations, inherent, and then B, that's A, B, inherent systemic issues, and C, hypothetical risks. And then on the page following C117, we set out in writing there, paragraph 40 following, what we say about the HTRC, the Technology Committee findings.
Yes, I'm afraid this tendency to use slightly different expressions to refer to the same thing is wearisome. But if we go back to the judgment, the full year argument and the mid-year argument, they did give reasons for. The jurisdiction agreement doesn't arise. The fairness argument, where do we find that in the submissions to the tribunal?
Well, so in the skeleton that was before the judge, quotes from the transcript that was before of the hearing before the appeal committee. So that's at B465, paragraph 81.
B465?
B465, paragraph 81.
Okay.
You have to forgive me because I haven't cross-referenced that extract from the transcript, but I will endeavour to find the page reference in the transcript.
And the monopoly argument?
Um,
Where is that in the submissions to the tribunal?
So in the submissions to the tribunal, if you go back to the, if you have your hand still in the February written submissions, you'll find the monopoly argument referred to. At page C114 and paragraph 30.
Sorry, C114?
C114, paragraph 30.
Sorry, did you say B or C?
No, C, sorry, my lady, I'm sorry if my
It
diction's
was
not
just the
good.
microphone. C for,
Yes, C for cat.
thank you.
Well, that's in your submissions to the court.
No, my lord. C114 is our appeal. Is our
Yes.
appeal.
The appeal application itself.
Yes, exactly.
Yes. And the HTRC agreement argument that we've seen, and the judge doesn't seem to place any reliance on the fragmentation argument.
No, it could be a subsidiary argument. But the point I wanted to come on to was the HTRC argument, which is I've shown you in the transcript where it was briefly referred to at the hearing under the pressure of time. What I wanted to focus on was, and I can do this briefly, is that when one looks at the first appeal decision, which is, and the cover letter written by Dr. Brathwaite, which is dated the 6th of July, that's at C137. And if you have that, if you could look at C138 at the bottom of that page.
Why are we looking at the first appeal decision?
Well, because the first appeal decision, this is a reference to a letter which the council say they're not taking this into consideration. So the first appeal decision accepted that they should not be considering effectively this issue of the HTRC reasons in broad terms, where they say, lastly, C138, lastly, the council notes the concerns expressed by the Health System Capacity Committee about self-referrals, i.e. testing facilities affiliated with referring clinicians. This was not considered by the appeals panel. The council expresses no view on the issue. Further study is required in the future regarding the question of approval of tied providers, given the concerns expressed by the committee surrounding the moral hazard.
But since this decision is effectively void, should we not just be looking at the second appeal decision?
I submit, my lord, not, because what the situation we've got is that the first appeal decision, we've made our point to the second appeal decision with regard to what we call the HTRC reasons, the technical committee reasons. And even the first appeals decision committee and Dr. Brathwaite in his letter of the 6th of July suggested that the council wasn't going to take them into consideration.
Well, I understand that, but I just don't understand why we're looking at the first appeal decision when this case is concerned with the second appeal decision.
because then, my lord, in the evidence which was filed by the council by Dr. Brathwaite, he then seeks to rely on those reasons, and that is found, my lord, at B151, paragraph 37 and 38. If you have that affidavit, which is Dr. Brathwaite's first affidavit.
That's an unfair characterization. I'm sure my learned friend will go through, but Dr. Brathwaite.
Let him take us, Mr. Adamson, let him take us through it.
Of course.
Paragraph 37, my lords and my lady, plaintiffs argue.
Just a moment.
B151. B151.
Yes.
Where Dr. Brathwaite then says the plaintiffs argue that their entry into the market for imaging would not negatively impact the SHB budget since it would replace but not increase current provision. The claim was, however, not based on documented analysis. The technology committee's view differed from the plaintiffs. And then he says at 38, I believe the minutes of the technology committee speak for themselves. That's a document I took to you before the break. But I do wish to elaborate on the various references to self-referral, since references can be misunderstood by those outside the industry. It is well understood that the healthcare industry, that there's often greater usage of services if service providers can refer patients to themselves. It is also well understood that increased capacity of healthcare technologies itself often creates additional demand. Increased demand for services will, of course, have budgetary impact. This is all in the context of Bermuda already having one of the highest levels of diagnostic testing provision in the world. Further, the technical committee was concerned with the dangers posed if this did occur, of there being insufficient demand to cover fixed costs. These are, I believe, valid concerns in the context of Bermuda healthcare system.
So all of those are matters which you can and no doubt did argue in relation to the second appeal.
Yes, well, I've taken you more to the transcript provisions which refer to the HT/C reasons.
Yeah.
I accept that we didn't have time to elaborate on those at the oral hearing. I think that the reason why I'm taking you to this issue, because it crystallizes the issue in terms of the giving of reasons. The point taken against us is, well, the tribunal didn't need to give you any further reasons other than to tell you that your mid-year argument wasn't accepted. But in my submission, that's not correct, because the committee had before it in its submissions these HT/C reasons, which are the technical committee reasons. These are reasons which the first appeals committee, the council in their cover letter say we're not going to consider, and then we have Dr. Brathwaite giving evidence about them after the fact. And in my respectful submission, the applicants or Dr. Soares is entitled to know and be told what the reasons were for the second appeal decision. It's not good enough that simply because the mid-year argument dominated the oral submissions because of time, that therefore the learned judge said in his ruling that the applicants in the judicial review were left shooting in the dark as to how they had failed to establish their application.
Right.
So, but I don't take that submission any further. That's the crux of it. There were more issues which were dealt with at the appeals panel. The reasons they don't give reasons, and the argument taken against us is, well, you should just go off and read the original reasons given by the original decision maker. Well, I mean, in my respectful submission, there's a lot of water under the bridge between those original reasons in December, January, and the second appeal hearing. And as a matter of fairness, Dr. Soares ought to have been told in clear language why the application didn't satisfy the council. And in my submission, that didn't happen.
Right.
That was all I was intending to say, unless I can help.
Thank you. No, that's fine.
In respect of the remedy, of course, I accept that the remedy ordinarily in a judicial review application is to refer the matter back to the original decision maker. I started out this morning taking the court through the chronology, and as I submitted this morning, by the time when the judicial review was heard in early February 2021, there was only a short 6-week period left in the 2020-21 year for SHB approval, if you like. Now, we've been through an original decision-making process, an aborted appeal with regard to bias, which the submissions were made to the council that there was a problem of bias in the first appeal, which was heard in May 2020. Yet the council ignored that and the first appeals panel ignored that and went ahead and put Dr. Soares through the time and expense of the first appeal without any justification whatsoever, which they then accept. So second appeal in September, which again was heard by an appeals panel, which we say in our case included individuals who were biased. And then we get to the decision, we get to the judicial review in February, where there's only, and I accept there's only a very small space of time left in the SHB year, in the annual cycle, as it's put, by the time the judge makes his decision. And therefore the submission was made that in the exceptional circumstances of the case, the judge should substitute his own decision. But
that can't be a ground. I mean, let's assume, bring it closer to home, that a court takes eternity to produce an answer. That can't be a reason for an appellate court to substitute its own view. Can it?
No, I accept that, but what I would say to that is that if I could ask you to turn to B424 of the B bundle.
Yeah.
And this is the exhibit to Dr. Brathwaite's second affidavit. B424.
Thank you.
Yes.
And this is the composition at this time. It's the only document we have in the papers which gives you a composition of the Health Council, which is close to the judicial review hearing. And you've got board members, and if I can just run down them, we've got Wesley Miller. He sat on the first appeal and on the SHB committee. Cynthia Thomas sat on the first appeal and the SHB committee. Anne Daniels sat on the first appeal. Michael Richmond sat on the second appeal. Shelley Henderson sat on the second appeal. Darian Ray sat on the second appeal. Sylvanus Nawab sat on the first appeal. Kristen Beasley sat on the first appeal. Dr. Braithwaite sat on the first appeal, second appeal, SHB committee and technical committee. We've been over those arguments. Dr. Oyo, as I think it's often pronounced, sat on the second appeal. I'll skip over Mr. Manders for a moment. And Siobhan Washington sat on the second appeal. So out of the entire Bermuda Health Council, by the time the judge gets to his decision, all except for Mr. Manders, who sadly died in early 2021. But I can give you the cross-reference to this, but Mr. Stephen Gift sat on the second appeal, and he was put forward as being the substitute for Mr. Manders, who couldn't be there. He was the assistant financial secretary. So even though the financial secretary is the ex officio member, Mr. Gift sat on the second appeal as the assistant financial secretary. And so in my submission, I accept it's wholly exceptional. The entire Bermuda Health Council had already been taken up with decision by the previous decisions. And this is a point which the judge refers to in his decision on his remedy argument or finding, and that can be found one at page A62 at 132, paragraph 132 of the judgment.
But Mr. Robinson, we can't rule them all out going forward. That would be totally impractical.
Well, I accept that for perhaps any fresh year application, but they couldn't sit again in respect of this year's application. They've already sat.
So in relation to whether one characterizes it as a mid-year or a full year application, you say they're disenfranchised from sitting on your mid-year application.
I do, my lady, because of course the council's already accepted by deciding that the first appeal was an aborted appeal for the very reason that people were sitting on the original decision-making body and sitting on the appeal.
But you're not saying that they would be disenfranchised, are you, from your outstanding application in relation to 2021?
Well, the Health Council goes through a cycle of where there's a cycle of appointments, so it's changing on an annual basis, or that may not be strictly.
Sorry, you're not answering my question. I don't think you've got an outstanding application in, yes, which is a full year application.
Yes, that's right.
For
2021,
22.
But you're not suggesting, or are you, that in relation to that full year application for 21-22, all members of the council are disenfranchised?
Well, my lady, I am, because I say that the decision making has relied upon the technical committee reasons. And that's been put. I've taken you briefly to the averment from the council saying the technical committee reasons are still a relevant consideration.
This wouldn't be an appeal, which is the basis upon which it was previously said that Dr. Miller and Ms. Thomas couldn't sit. We understand that they were appealing from their own decision. But if a fresh application is made, surely that's a different circumstance.
Well, my lord, if circumstances have changed, but circumstances haven't changed, the council still has no different position in terms of its approach to an application from Dr. Soares.
Well, the manner in which the Health Council dealt with the second appeal was to appoint persons who were not members of the Health Council. Yes,
that raises a point, my lord, which is not really fleshed out.
That's the manner in which the Health Council constituted a body for the second appeal.
Yes, that's correct, my lord.
And do you say that was a proper thing to do, bearing in mind that there were insufficient council members who had not been involved? But was that not a step which the Health Council had to take so that they could get a quorum for an appellate body?
Well, my lord, we don't take this point in the judicial review, but the answer to the question is that the quorum for the Health Council is section 6.8 of the 2014 Act.
But that's for Health Council meetings. Yes. In relation to appeals, and it's an ad hoc process, if you like. But even in the ad hoc process, the Health Council's own criteria say in terms that they can go outside their own membership for the appointment of an appellate body.
I accept that, my lord. The point I make in respect of that is that even though that is in accordance with the appeal criteria, when the Health Council communicate the decision of both appeals, they say the council has decided. They don't say the appeals committee has decided. They say that the council has decided. That's the letter that I've just taken you to in respect. If I can ask you to turn back to C253. I may put that too strongly because the letter says the Bermuda Health Council requests to inform you that the appeal has been denied.
We can't take exception to that, can you?
No, you're quite right, my lord. I can't take exception to that. So again, you'll come back at me and say that I'm not entitled to go to the first appeal, but if you go to C137, which is the letter of the 6th of July 2020, after the first appeal.
Yes.
And you'll see it 2 paragraphs up from the bottom. Following review by the committee, the matter has been placed before the council. The council has met and determined to reaffirm the January decision, not to approve your facility at the present time. The reasons are as follows.
Yeah, but I mean, that's what I have a problem with, because this is the first appeal decision and we're not concerned with it.
No, I accept that, my lord. I simply raise this point because in paragraph 132 of the judge's ruling, he refers at 132, which is A62, at B little I. He says, based on the historical timeline, there's likely to be further delay by the respondent in one constituting a fresh appeals panel and secretariat.
Yes, well, they may have to select people from outside the council.
Yes, my lord. I don't take the point beyond that. I'm simply dealing with the judge's reasoning for in substituting the decision. The second point which I wanted to make on this issue was if you can read the previous paragraph, the final sentence, he says, paragraph 131, final sentence, the public interest is also protected by the existing powers of the BHC in dealing with the annual reapplication process for incumbent providers as and when they choose to apply it. And so I accept that the judge's ruling came out in the following approval year, which related to the year following the year we're dealing with. But the judge is alive to the point in 131 in the last sentence that his order of granting approval is subject to the ability of the council to run a fair application process in respect of both Dr. Soares' application and incumbent providers.
Well, we're considering the reasons why the judge felt able himself to make the decision. Some of them are at times gone, the time has passed, which doesn't seem to me a justification at all. Some is that there may be problems in constituting a fresh appeals panel, to which the same applies. Then at G, 132G at the bottom, he says, I'm not persuaded that an additional service provider will increase the quantity of testing and thus costs. Rather, I'm the view that testing will be shared amongst all the service providers. Well, he may be of that view, but unless that's the only view that could be taken, I'm not sure that the fact that he took it on the 8th of April is determinative of who should be deciding the question. And then according to the BHC itself, self-referral causing a negative impact on the budget is not an issue. I want to come back to that in a moment. And I, the applicant's application that was submitted on a full year application, has a reasonable prospect of success on its merits.
Yes, my lord, I have to accept that the judge in his in the final sentence of paragraph 132 is making a substantive finding of reasonable prospects of success. And I accept that Reblast, it was a different case because the judge in that case found that there was only one way the tribunal could have decided. So I can't argue the contrary to that. That's clearly a different situation. We simply drew the parallel with Reblast, because it was a case in which there'd been procedural unfairness, and the court had substituted its own decision. So all I can do in this appeal, my lord, is to point to the points in which the judge has referred to in terms of the difficulties with having an appeal panel, the ability of the Health Council to actually, the judge has put it to have a fair process, but of course we have actually made an application for the next year.
Yes,
but it hasn't been determined.
No, it's obviously what ought to happen.
So,
but
I can't put it any higher than that.
I know, but there is a difficulty with the judge's approach. Firstly, he proceeds upon the basis that the application should have been regarded as a full year application, about which we've had a lot of discussion already, and which on any view is questionable. But even on that hypothesis, all that he decides is that it has, all he appears to decide is that the actual application submitted on a full year basis, namely that submitted on the 30th of June 2020, has a reasonable prospect of success. But the order that he has in fact made proceeds on the assumption that the application that was made in March 2019 should be treated as being made on a full year basis, and we should proceed upon the basis that on a full year basis it was bound to succeed. Because if it wasn't bound to succeed, it wasn't for him to decide whether it would succeed or not.
I accept that, my lord. I accept he doesn't say it was bound to succeed. He says it at a reasonable prospect.
Yeah. Well, it's not for he's not the decision maker.
Well, I accept that.
Well, this must be wrong, mustn't it?
Well, I accept it's very difficult to understand the justification.
Difficult to understand, and insofar as one does understand it, it's erroneous.
Well, I'm simply trying to put forward the points which are in favour of the judge's view.
Yes, well, that's very noble of you. But I mean, it seems to me, at any rate, it's maybe too swift a view, but it seems to me that the judge substituting his own decision just isn't on. If that be right, and I use the expression "if" intentionally, if that be it assumed that the judge wasn't entitled to make his own decision, and be it assumed also that you are right on the question of bias. You follow?
Yes.
The question would then arise as to what we should do, because on that hypothesis, the judgment of the second appeal tribunal cannot stand, but the decision of the judge to substitute his own decision for that of the second appeal tribunal can't stand either. Subject to what I'm about to say in a moment, it would seem to follow that prima facie, we would set aside the judge's order and order the appeal panel, possibly newly constituted, to consider a third time whether or not the 6th of March 2019 mid-year application should have been granted.
Yes.
That would be an exercise devoid of useful purpose, because even if the 6th of March 2019 mid-year application had been granted, it would now be spent.
Yes, Lord, that's quite correct.
Right.
My only response to that is, in terms of the question, is there a utility in the court making any other order? Is that, of course, the court is entitled to grant a declaration that Dr. Soares wasn't, as to what he was entitled to have done with his application, which is now for a year, which is spent.
Well, that might be, that would be, it wouldn't take matters very far. He would be entitled to have his mid-year application determined as a mid-year application by a tribunal that wasn't infected by bias.
Well, my lord, that assumes that you're against us on the issue of the full year as against mid-year. I mean,
yes, it does. Well, yes, it does. But even if I was with you on the full year point, it would mean that he was entitled to have his application made in March 2009, treated as a full year application, 2019, treated as a full year application made before 1st July 2019 in respect of the year 2020 to 2021. Let us assume that we were to declare that he was entitled to have the application considered on that basis. That wouldn't help him either, because we've got past April 2021.
Yes, but Lord, with respect, it would be of utility because of what Dr. Brathwaite says at paragraph 34 of his first affidavit, which is at page B 150 to 151.
Right.
And at the very bottom of that page 150, it starts, and it's really the last part of that paragraph. It's appreciated, the council appreciated the applicant's point that this meant that they could not make a full year application as they otherwise could. This was, however, out of the council's control.
Which paragraph number?
Where are you reading from?
Paragraph 34, B150. At the very bottom of B150.
Well, I was looking at that, but I didn't see the passage.
So it starts if you at the very bottom of page, the very last word on page B150 is the word it.
It.
And then
I see.
On the next page,
yes, I follow. It.
Yeah, it appreciated. I'm sorry if that was not clear. It appreciated that the applicant point that this meant that they could not make a full year application as they otherwise could. This was, however, out of the council's control. I point out that contrary to Mr. Soares' claim, the delay did not mean that the applicants could not make a full year application. First, there is a moratorium. Second, there's been no rebasing exercise for the SPR since prior to the application, and therefore no applications could have been or can currently be considered on a full year basis. And so
but they've since resiled from that. I thought they were considering Dr. Soares' full year application.
Yes, except that they haven't, Lord. They didn't consider it. They haven't communicated any decision. They simply, in the light of the judge's findings and ruling, have decided that they can't decide it. So the question I'm trying to address is the question from my Lord President as to what could the court grant a useful declaration. Well, I say that the court could grant a useful declaration because if Dr. Soares was entitled to have his application considered on a full year basis by an unbiased panel, that takes us very considerably further than where we might be with regard to any further applications. We're almost already through another year of approvals also, my Lord.
Well, that's another problem. I mean, the application that was made on the 30th of June 2020 governs the period from 21 to 22.
That's correct.
We've almost got to the end of that. We've got not much less, not much more.
That's correct, Lord.
Was an application made on by the 30th of June 2021?
No, it wasn't made on 2021. On the basis that the council had decided that they were now going to treat Dr. Soares as an incumbent. And I think also well, this is not on the evidence that the application form no longer exists on the council website.
Oh.
The answer to the question is that there was no application made on the 30th of June 2021. Because by that stage, the council's position was Dr. Soares was an incumbent and he was therefore being treated in the same way as all the other incumbents.
Good Lord. All this could have been avoided if the application made on the 30th of June had been progressed.
I don't disagree with that, my Lord.
Can't imagine how we've got into this position. We've now got to a situation where if we're against you, if we're in favour on bias, and even if we're in your favour on mid-year treated as a full year application, you're going to get a declaration. Well, the ruling of the judge will have to be set aside, query when exactly, and you'll get a ruling which might be thought to be a statement of the obvious, that you're entitled to make a full year application and have it determined by an unbiased tribunal.
Well, my lord, that's exactly what we haven't had in my submission.
No. Well, I asked Mr. Adamson what's going to happen. Is it then going to be said, it's not really a question for you, Mr. Robinson, but it is a question from Mr. Adamson. If we were so to declare, is it then going to be said, well, that's true, but irrelevant because there's no application made for the year 22-23?
That's a technical point is unlikely to be taken by my client. The application, there is a full year application in place, which has been made, which the intention is to progress that very
For which year?
Well, it was filed, of course, June 2020.
Yes.
A year commencing 1st of April 2021.
Yes.
But the intention is to consider that application appropriately and fully, and if it would be granted, we would grant it, as it were, back when it should have been granted. So,
but what about going forward? I mean,
yes,
and going forward. And
that's the point. I want to hear from you, Mr. Adamson, in reply, as to how we get out of a situation which is all historic, but in circumstances where it is possible, if we were to accept Mr. Robinson's submissions, the decisions were vitiated on the grounds of apparent bias. I mean, that, it's where we go from there, it seems to me, is what I'd like to hear from you on. I haven't made up my mind yet, but I'm just saying.
No, but you're seeking to consider the practical ramifications. I mean, first, if that were the decision of this of the Court of Appeal, then what that means is that the SHB decision remains, and therefore the appeal may be quashed, but the original decision of the SHB committee from December 2019 is in place. And therefore,
not necessarily at all.
Well, there was no challenge to that decision, so that ordinarily would remain extant because it's never been challenged. But your question really is about the future. If Dr. Saul's application was approved, whether on a mid-year, full year, or at any stage, he would become essentially an incumbent, and therefore treated like all the other incumbents, and he would benefit from any rollovers or carryovers or during the reform process. As I've sought to labour, the real difficulty for applicants is getting into the system. They have to show there's a need for an additional provider of the services, and so on. And once you're in the system, you are treated the same as all the other incumbents. And that is the importance of the mid-year. If he had been approved as a mid-year, then on all future applications, he would be already within the system, and he would not need to show a need for an additional service provider of this benefit because he's already providing it, and he's not a new entrant. So the mid-year did have a purpose back when it was made.
That is an argument against you, isn't it? For us making some effective decision in relation to a historic mid-year application.
Well, I don't wish to make arguments against or for myself in that tactical way. That is the way the system works. The new entrants have a burden, an additional threshold to get over. And one assumes Dr. Soares, who made the mid-year, thought, if I can get into the system, then it'll be beneficial. And so there would be no technical points taken, I believe, by my client in terms of saying, oh, well, your time's up, we're now in a different year and so forth. That's not the way the system is run.
Are you saying, Mr. Adamson, that in relation to the full year application, which has not yet been determined, that the council would consider that on the basis that Dr. Soares was already in the system?
No, in our view, the proper way to deal with the full year applications to deal with on the basis that he is a new entrant. But we can't do that at the moment because because the court has said no, he's now within the system. But the proper way to have dealt with that would have been to deal with it as a full year, as a new entrant, and so on. Now, and indeed, so if you quashed this decision, if you set aside the learned judge's decision granting approval, we would deal with the full year application as filed and deal with it quickly with as many external members as are necessary, and deal with that. But it would be dealt with, in my submission, as an application to join the system. Now that's simply my instinctive position as to what would be the case. But of course, if you were to say, you know, he needs to be approved as a mid-year or be approved, then obviously that would change the analysis. But we have to do an analysis of the system, the costs, and the pros and cons for any new entrant.
Yes. Well, on that footing, you say you weren't able to consider him as a new applicant following the judge's decision because the judge had installed him as a provider, and once he was an incumbent provider, he didn't have to satisfy the test of a new applicant. So what on that footing were we supposed to do? You say that in order to enable you to consider him de novo and not as an incumbent provider, we would have to set aside the judge's decision that he is in effect that he is to be treated as an incumbent provider in order for him to be able to process the fresh application as a fresh process as a completely new application, the application made on the 30th of June, at a time when by reason of the order that we will have made, he won't be entitled to provide the services that he was entitled to provide pursuant to the judge's order and might be entitled to provide depending on what you were to determine in relation to the 30th of June 2020 application.
Yes, we would go through the proper process. There would be an extant appeal on the mid-year, and there would be, secondly, there would be an application on a full year basis for entry. Now,
but what's going to happen is that having started his practice pursuant to the judge's order, he's then got to stop it until such time as you deal with his full year application.
It may be I can talk to my client about about that, but essentially the difficulty is we have to deal with these. There are so many providers in Bermuda who provide outpatient services, not just diagnostic. We need to make sure that the system is applied fairly and in accordance with the playing field as is set by the policies. Now, therefore, we want to do things properly, and that there will be a mid-year application appeal, and there'll be a full year proper application. Now, it may be that my learned friend's client will say, well, don't bother dealing with the mid-year application appeal. I don't want to proceed with that anymore. It's pointless. And that's up to him. And then all I can say is we would devote sufficient time and resources to make sure this is done quickly and properly.
Mr. Adamson, a comment that you made about other providers. There are no other providers seeking to provide the diagnostic imaging services that Dr. Soares is seeking to provide, are there?
Only the incumbent, but two separate, technically two entities which have shared ownership. They're the only non-hospital outpatient providers. Right. But of course, there are other providers of other benefits, dialysis and all kinds, who look to the rules to base their investments and expect the rules to be applied.
Yes. Mr. Robinson, I'm
Lord,
taking things slightly out of kilter. Had you finished or not?
Yes, Lord, I'm grateful for you coming back to me. I had, in fact, come to the end of my submission unless I can assist the court further.
Not at the moment, thank you.
My lord,
Right.
could I just reply for 5 minutes?
Yes, of course.
I'm grateful. On remedy, the test is, was there any one rational result? That is the test. My learned friend in the skeleton accepted it. I thought we all accepted it, and that's it. There is no single rational result, and therefore the learned judge was wrong to substitute a decision, and that is it. Turning to rationality and the arguments in particular of this morning of my learned friend about the incumbents being pulled over and somehow this meant that the only rational thing to do would be to treat the mid-year application as a full-year application to somehow deal with that perceived unfairness. The difficulty with this rationality attack is not only does it assume that we had to treat an application as something which it clearly wasn't, but secondly, my learned friend didn't answer the question of what was the appeal panel supposed to do in September 2020? Because the argument was and is that in September 2020, the appeal panel should have at that point given approval effectively blind, without knowing what the impact would be upon the SHB budget, because there'd been no analysis which you would need for a full year application, such as the actuarial analysis and all the rest. And the idea that in September 2020, that was the only rational decision open to the appeal panel, I say, is very much a stretch. And my learned friend ignored the point I made on Friday, which was, in addition, for both applications, mid-year and full year, and this applied therefore, if you characterize it or say we should have characterized it as a full year, for the need to show why the system required an additional provider. And that factor, requirement, question remains unanswered. And my learned friend has criticized the expert or the technical review panel, that's the HTRC, for all those parts of the advice which concern self-referral and concerns about practices in the industry. But he hasn't touched upon the part of the advice or the analysis which goes to, is there a need for an additional provider within the system? That passage in the advice, my learned friend did not touch on.
What about the point, Mr. Adamson, about the need for somewhere in the city of Hamilton, which is the business centre of Bermuda?
Well, clearly the experts...
Is it the capital city of Bermuda? I believe it is.
It is.
Yeah.
Yes, it is the capital city.
Well, my lady, of course, Bermuda is not large. I mean, I appreciate there may be a convenience factor, but in an island which is 20 miles long, it isn't, shall we say, this isn't Texas, and there was no analysis or data showing that having that convenience was necessary for the system, or that patients were going untreated because they couldn't otherwise get to the other diagnosticians.
One just has to speak from one's knowledge, doesn't one? That if one's working in the city of Hamilton, which I have done for many months, if you've got to get to the doctor in your lunch hour, it's quite difficult to get out to the other end of the island.
Well, I don't believe they are on the other end of the island, but one of the...
I mean, I think we can take it they're within half, 3/4 of a mile, both of the other providers.
Yeah, I mean, one of the providers is I believe, next to essentially on the foot of the lane. I mean, it is not far at all.
There's no difference in distance between going to the hospital and going to Bermuda Healthcare Services.
Yes, exactly. So I appreciate there may be an argument about convenience, but here we're talking about need from a systemic point of view. does the system require a diagnostic unit within the city of Hamilton? And there's no evidence that the system requires it or needs it. It may be a convenience, it may be a nice thing to have, but from a system perspective, it's not. There's no. It simply was not demonstrated that there is a system need. Turning to, so as I say, the requirement to show this is, does the system need an additional provider of diagnostic services? Has, with respect, been glossed over by my learned friend, and yet it's central. It was a central finding by the SHB committee that there wasn't, based upon the clear advice from the experts that there wasn't. I do say it's in and of itself dispositive. Turning, so that deals with rationality and so on. If I can deal quickly with the arguments of bias. The learned judge expressed concern at the presence of Dr. Brathwaite, but he drew no inferences that Dr. Brathwaite's evidence was not accepted. And he at no point inferred that Dr. Brathwaite was not telling the truth. And neither, with respect, should this Court of Appeal. Second point, this is not a case of a decision maker sitting on appeal of a decision which they have made. Dr. Brathwaite was not a decision maker. He says so in his affidavit. In his third affidavit, he states in terms, I did not make the decision. I'll read it out rather than I'll turn to it, but it's B436, paragraph 5 of his third affidavit. I confirm that I do not take part in the decision making or discussions about the decision. I do not take part in the decision making or discussions about the decision. He's not the decision maker. He is not part of the decision making. Second, it's never been suggested that he has a position or some interest which above and beyond having sat on the previous committees. So I do say this is not a case of bias as normally understood. Indeed, the way it is put, and I say more properly put, is on the basis of the case of Ward and Bucks, the case of Lord Denning, which relied upon by my learned friends, which said tab 20 and cited by the judge. Sorry, Ward and Bradford Corporation, tab 20, the Lord Denning judgment, where he doesn't refer to bias. He says it is contrary to the rules of justice and that justice, just the need for justice to be done, for an outsider to be present while the decisions are being made or discussed, if that person has no right to be there. And as we went through on Friday, in Ward, there was Mr. Naismith, and it was claimed that he had no business being there. And indeed, Mr. Naismith made comments and voiced an opinion in favor of a particular outcome. He stated, and we went through this, but it's at page 5, bottom paragraph, Mr. Naismith, when they all retired to determine what they should do, he voiced the opinion that the circumstances in Miss Ward's case, one of the people under disciplinary sanction, was more serious than the others. He gets involved in the discussions, and the question was, well, he shouldn't whether he should have been there because he was not taking part in the decision. And this, as I say, is a decision put forward by my learned friend, and I accept it as containing the appropriate test. And Lord Denning said the test is, again, we went through it, but page 5, I quite agree that in general, no person ought to participate in the deliberations of a quasi-judicial body unless he's a member of it, nor should he retire with them for their discussions, lest it be give the impression he's taking part in their deliberations when he's not entitled to do so, for then justice will not be seen to be done. Now, let's apply the test of Lord Denning as he applied it in that case. And I say, Dr. Brathwaite was entitled to be there, not to take part in discussions, but to be there. Indeed, the appeal policy guidance said he needed to be there and he should be there. So no one will be surprised This is that appeal guidance is C24, paragraph 9.3. And there's no evidence, unlike the case of Mr. Naismith, that he took part in any of the deliberations. Indeed, he says he did not. Now, Mr. Naismith did, and as a result, they put in evidence to say he made a mistake, he got involved in discussions, but it didn't influence anyone. So they brought evidence to show no harm, no foul. Although he said these things, it didn't sway our minds. But no one suggested ever that Dr. Brathwaite said anything to influence anyone. So why is this case being put forward as authority that it's incumbent on my client to be putting forward evidence from the other committee members? As I say, the test isn't set out by Lord Denning, and if you apply the test to our case, Dr. Brathwaite, it was not a breach of any natural justice for Dr. Brathwaite to be present. Dr. Richmond, you've got my submissions on that. I do say that, and I'm grateful to my learned friend for his acceptance that the issue is apparent bias, not actual. But on apparent bias, as I say, it's simply not there. The hospital does not have skin in the game. And indeed, that was a point made rightly by Dr. Soares in the transcript. If I then come to the issue of reasons, the first point is 90%, if not more, of the transcript was devoted to those two arguments, statutory interpretation and the mid-year versus full year. And I appreciate my learned friend says, well, he could have gone on for longer, but the appeal panel were entitled to focus on the arguments which were put before them and clearly were the center of the case. Second, this is an appeal. Of course, we can look at the original decision. And indeed, I did not hear my learned friend to really contest that point. This was an appeal decision which voted to uphold the previous decision. And of course, they're upholding the findings. And again, those findings by the SHB committee were stark. First, that the application did not show budget neutrality or cost reduction. And secondly, that the application had not shown any need for an additional provider of diagnostic services, both central findings which remain in my submission undisturbed. And third, the learned judge says, well, we didn't deal with other arguments, but as my learned friend pointed out in submissions this morning, there was an overlap. Fairness and the treatment and monopoly arguments overlapped with his main point about treating it as a full year. He was saying, treat it as a full year because that's the only way to be fair. That's the only way, and give approval now as a full year because that gets over the monopoly issues. So these were arguments being deployed in support of the central argument. Fourth, my learned friend criticizes the HDRC advice and says because he set out criticisms in writing, they needed to be dealt with. But did they? All the criticisms which are made in the appeal documents about the HDRC advice, and of course it was only advice, concerns, as I say, the self-referral issues. There is no attack of their central advice, which was that there is no need for an additional service provider of diagnostics. There is no attack on that finding in the appeal documents, the appeal document being the grounds of appeal, which are page, which my learned friend, as it were, prayed an aid to go along with his oral submissions. So I do say when it comes to reasons, that the laconic, and I appreciate it's laconic, but the laconic minutes of the appeal panel were adequate. And it is not right to say anyone was shooting in the dark. We have been stating since we're blue in the face that the application, unfortunately, did not meet the guidance. The guidance has two aspects. Both aspects were not demonstrated to the satisfaction of the SHB committee. And in my submission, there was no basis for suggesting that the appeal panel should or could have come to a different view.
The two aspects being the need for an additional provider
And budget neutrality.
Yeah.
Because, yes. My lord, I've rattled through those. Those were my main points in reply.
Yeah, thank you.
I'm more than happy to deal with any questions about the practical nature of things.
Let's just, before we get to the practical nature of things, go back to the theory. What the Bermuda Health Council has done is to pause the annual application system so that incumbent providers of services don't have to apply.
Don't have to reapply, yes.
Don't have to, yes, don't have to reapply. Is that something that is open to the council in circumstances where the standard health benefit proposal guide calls for incumbent providers to reapply each year?
Yes, my lord, because the only statutory duty is to give approval. That's our function under the regulations, to give approval. There's nothing in the regulations talking about how we do it. We have a policy document, but we can depart from policies for good reasons. And here we say there is a good reason. And indeed, and indeed, my learned friend's case was that by refusing to depart from the guidance, in his case, we fettered our discretion because, of course, a policy can always be departed from. And he's right.
Yes. But assume for the moment that there wasn't a ministerial intimation that the government or the minister was not going to alter the premium, as indeed he or she hasn't for a couple of years, so that things were proceeding as normal. Would it be open to the council to say, oh, well, incumbent providers don't need to apply each year? I know it says that in the guide, but that's only a guide.
Well, it could be in hypothetical point when the entire annual re-application process could be fundamentally changed because it's so expensive to rerun the process, and just instead to have a process which deals with new entrants. That's a possibility. It's a hypothetical. At the moment, they in ordinary times, they look at everything afresh each year to see what the costs are and how the costs are changing. But of course, and I hope I'm not going to annoy by making the point to laboring the point. A new entrant is in a different position to an incumbent because of the need, as set out in the policy, to show why they should be there. This is not a free market; it's a regulated market. It's like the NHS. You can't simply say, "I've got a clinic in England. I now want to get some of the NHS funds." You can't just say and then say, "Oh, well, that's terrible. It's against open competition, but I can't be competing with that NHS primary care hospital over there, or that NHS diagnostic clinic over there."
Can you say I ought to be allowed as a clinic because I provide a form of service which, although provided a diagnostic service, which although provided by one other unit, will be much better provided in some respects by me?
That argument may well persuade some regulators. You could say you are providing a unique solution to a problem, and you're just the ticket for our system. Our system will improve because of it, and we're persuaded that, for example, there's not going to be any increase in cost, or if there is, the costs is more than justified, and that's if the SPR needs to increase, then so be it. So be it, because these MRI open scanners are what we need for shall we say, an obese population or an elderly population or a population which can't move very well. These are all arguments which would be highly relevant factors and which were considered here, considered by the experts who went through the very arguments eloquently put forward by Dr. Soares in his application, and they considered them.
Right. Okay. Well, for myself, I don't have any further questions. I don't know whether either of my colleagues do.
Not for me.
No. Well, thank you all very much
Very grateful.
for a most interesting set of arguments. We will endeavour to give judgment in due course.
Thank you very much.
Thank you, Lord Malady.